Right, good morning, everyone. Do we have here everyone we're expecting?
There's some printing that's been done by my team at the moment.
I had said 9:30 on the basis that we might get through things a bit faster, but I'm happy to open a bit later as long as we're all agreed about what time to be here. I don't want to sit waiting for people.
Certainly, as I say, I'm waiting.
Well, should we say we'll start at 10? Okay, I might wander off and come back at 10 o'clock then. Okay, everyone understood? So I should just also say, I noticed that the door was locked when I got here. It's a public inquiry. I've got no idea if people have arrived at the building and gone away because they can't get in. Are we expecting anyone else in terms of third parties to appear? Do we know?
We're not on advance notice, which is in my understanding that the 9 a.m. this morning.
They definitely weren't. I had to bang on the door, and it was a bit of a struggle to get in the building, which isn't really what's appropriate for a public inquiry. Someone should be able to come and go as they please. I'm just concerned if there's anyone else that's wishing to appear before me to speak in terms of interested parties.
I will double check that my officers are back, but there's no one
Okay. Mr. Cottle, do you know any differently? Okay. Right. Well, then let's say we'll start at 10 o'clock, and that'll give a chance for the printing to be completed and everyone to come back at 10. Thank you. Right, good morning. It is 10:43 and it's time for me to resume this inquiry into the appeal made by Mr. Russell Gray of Shiva Limited against the decisions of the London Borough of Hackney to serve two enforcement notices, one alleging the erection of 4 unauthorised structures at roof level, the installation of a platform and decking at roof level, and the installation of fencing around the roof edge, one alleging the material change of use of the land to a mixed-use restaurant and bar, the display of art installations, cinema, and use to host social gatherings / as an event space on land at the Regent's Canal and Brunswick and Columbia Wharf, 53 to 55 Laburnum Street, Hackney. By my reckoning, this is the 8th day of the inquiry if I include the site visit on the 23rd of September. The usual reminders, please, electronic devices off or on silent. Is there an attendance sheet circulating for today? Thank
So
you.
there is.
Great. Now, the purpose of today is, as far as I am concerned, closing submissions and costs only. I don't know how long this might take. And what I was going to say when I opened at 9:30 is that I would take a break mid-morning, a break for lunch if we're still here, and another break mid-afternoon if we're still here. But I don't know how long things might take. As far as I'm concerned, I've heard from all the witnesses, and there's nothing else that should need to be done today. But I was going to do the usual thing of asking if there's anybody else present who wishes to speak who hasn't already indicated that they wish to do so. But as I've expressed already this morning, I'm concerned that when I arrived at 9:30, which was the start time for this inquiry, the door was locked and I had to bang on the door to get in. So I've got no idea if there were any interested parties who wished to come along and say anything today that they haven't had the opportunity to do so far. Do either of you know if there's any interested party who wishes to attend, or does anyone else in the room know if there's any interested party who wished to attend to tell me anything this morning?
So we're not aware of any other interested parties that wanted to attend. Mr. O'Connor's email address was on the notification that went out for today's hearing, and he hasn't received any responses, and
Okay.
nor has the officer team at the council. I need to apologise for the fact that the venue wasn't open to the public at the time that it should have been. It is now. I am told that, in fact, there was a facility if people had thought about it and done it to potentially have got in using a doorbell, but I appreciate that that's not sufficient in these circumstances. But what we can say is that, having spoken with the security and the facilities management team, is that they're not aware of anyone attempting to come into the public venue before the time that it was properly opened. And so we have no reason to think, as it were, that there is anyone remaining who wishes to address the inquiry who hasn't already had the opportunity to do so.
Thank you. That makes me feel slightly better. That's good. But it does appear to be that there is a miscommunication between whoever is booking the venue and whoever's providing the venue, in that the staff downstairs don't appear to have any awareness of the public nature of this inquiry, and they don't seem to be willing to let people in off the street if they wanted to do so. So I'm just concerned that they might not be aware of how this is meant to work. I wasn't expecting any interested parties to turn up today, but you never know. And I think from previous days they might have been waiting to speak to me, but I don't know that that's the case. I've not had any inkling that anyone was expected today, but I just wanted to make sure. Are there any procedural or housekeeping matters? For example, any fire drill or anything else that we need to be aware of that may disrupt proceedings today? Okay, thank you. In terms of documents, a couple of things have come in that I wanted to flag up. I've had an amended application for costs from the council that I've recorded as document 16, and I've had an amended application for costs from the appellant that I've recorded as document 17. I've run through everything else on a previous day, so I don't think there's anything else, but does that align with what you are both think is the situation in terms of documents?
So it does. I think both myself and my learned friend have some authorities to provide you with today, along with the closing submissions, but those are the only additional documents that we are certainly proposing to introduce at this stage.
Are they authorities I'm not already aware of? Those listed, I've got Safe Rottingdean and the Ocado case. Are they
So
additional?
they are additional
Okay.
authorities.
And sir, on behalf of the appellant, a couple of documents that we're going to be handing up today. They relate to the green wall policy in the development plan for Hackney and in the London plan.
Is the council aware of these documents?
I've passed them to them. They're their own development plan, of course they are. They're just the policies.
Right,
so
just
it
the policies.
shouldn't be contentious.
Right.
There is another item as well, sir, that I'll be handing up during my closing submissions, which I've given to my late friend already, which is a document that you don't have. And that was Mr. O'Connor's response to the request to complete draft statement of common ground. It's my submission. But if you look at that document and you see what Mr. O'Connor crossed out and didn't cross out, you can infer from the matters that he didn't cross out, for example, the site description, that it was agreed.
Does this go to costs or another point?
No, it just goes to making your decision easier.
Okay. Right. Now, I have asked that I have a hard copy of the closing submissions from each side and also an electronic copy emailed through. Do you both have those?
So we do. I have hard copies here with me, and I understand that the electronic version has already been sent via the usual PIN's address.
I've seen an email from Christine Stevenson. I assume that's the council's closing.
So I suspect that's it.
Yeah, okay. And don't think I've had anything from the appellant. Great. And also the amended costs application from the appellant. I'm aware that it's come in, but it's arrived too late for me to print. So I'm hoping there is a hard copy that I can be given at the appropriate time. Yes, nodding. Okay, great. Right, are we ready to begin with the council's closing submissions then?
So we are. I'll just circulate the hard copies of those now.
Can we ensure that electronic devices are off, please? I keep hearing things pinging. Thank you.
So thank you. So just to explain briefly the bundle that I've just handed up, it has the closing submissions behind tab 1, the council's updated cost submissions behind tab 2, and so just so that you're aware, those cost submissions have been updated in very minor respects, essentially typographical ones, since the last version was sent through. It's been provided to my learned friend.
So I haven't seen this latest version.
You won't have seen that latest version, but if you remember the previous version, you will see as we go through this just how close they are in terms of their identity. And then after that, just for convenience in this file, I've produced behind the further 3 tabs the additional authorities that we're going to invite you to take account of. And of course, I will explain in the closing submissions as I go through why we say they are relevant. So, sir, these are the closing submissions on behalf of the local planning authority. And as was said, by way of introduction, I note that as was said on behalf of the local planning authority in opening, this appeal is concerned with the grounds raised in relation to 2 enforcement notices, nothing more and nothing less. And so these submissions deal first with the 2019 enforcement notice, which addresses operational development on the land, and then with the 2020 enforcement notice, which addresses material changes of use. of the land. And at the end of what, at the appellant's behest, has become an exhaustive discussion of all the issues the appellant wished to raise, the questions posed by the appeals are clear, in the sense that for each ground of appeal there is a clear route to show why the appeal should be dismissed. In each case, there is at least one route that shows that maintaining the appeal was unreasonable. For the reasons set out below, the appeals should be dismissed. But before turning to the substance of the appeals, it is appropriate to briefly address some miscellaneous matters, principally those raised by the appellant. So I turn first to the judgment of Mr. Justice Murray given in the High Court proceedings. And in relation to that, sir, we say it remains but this judgment is not before you, sir, for consideration. Bearing in mind the appellant's misconceived but continued determination to rely upon this judgment, it's important to note some features about it. Mr. Justice Murray was dealing with an interim application for a planning injunction under Section 170B of the Town and Country Planning Act. In doing so, he was applying the conventional Porter test to the interim situation, which expressly requires him to take the council's planning assessment as a given. He had not visited the site. He did not hear live evidence. Evidence was not tested before him. And of course, he reached his determination based on the tests which apply at the interim stage of High Court proceedings and do not require final conclusions, still less any final conclusions in relation to planning matters. He did not make any final finding about the previous use of the building for the display of art installations, still less that there had been any use beyond the ancillary or incidental. And so, sir, put simply, his judgment does not assist with the issues currently arising. As you said, and the council agrees, you are fully entitled to reach your own views on the matters within the appeal with the benefit of tested evidence and multiple site views, and there is nothing in the judgment which constrains what you can decide in that respect. Similarly, in relation to the stop notice and the judicial review proceedings, neither the judicial review proceedings nor the stop notice on which they are based are before you. The proper construction of that notice and its legal implications will be tested in those proceedings, and so you know that I say the proper construction of documents is a matter of law. As Mr. O'Connor pointed out, in those circumstances, the clarification documents have no implications for the validity of the enforcement notices that are before you. And dealing lastly under miscellaneous matters with the position of Historic England, any reliance on an absence of comment by Historic England is misjudged for the reasons given by Mr. Dyer. They will not provide other than generic comment on a case of this kind, which falls under their relevant thresholds. Consistent with that, it can be noted that the appellant has not sought to produce any material from Historic England which is supportive of the proposed development. And as Mr. O'Connor pointed out, the fact that these issues are being dealt with by enforcement notice rather than planning application means that views are not canvassed in the same way as they would be during the course of a planning application. Accordingly, it would be a bad assumption to think that the letters of support that the appellant has produced are reflective of a more general public position. And so I've referred in footnote 7 there to the social media effort that the appellant accepted was undertaken with a view to as it were, generating some support for the proposals that are before you. And so with those preliminary comments in mind, I turn now to the two enforcement notices and the grounds of appeal, dealing first with the 2019 enforcement notice. And that was made on the 18th of October 2019, directed to 4 structures and ancillary works that were present on the site at the time, as set out in the notice. And of those, as we know, the Potemkin Theatre is now gone. Structure number 3, HVAC, has been partially or perhaps now wholly dismantled. But as is common ground, so you have to decide and test the enforcement notice against the structures that were present as at the date of its issue. And so on that basis, I turn to ground C. And in relation to ground C, we say it remains utterly unclear on what reasonable basis this ground could have been substantively pursued. Mr. Gray, in his evidence, said the Potemkin Theatre and HVAC were expressly temporary structures. The fact that the Potemkin Theatre has, after years, been largely removed does not mean it was not operational development, as at the time of the 2019 notice, when it was undoubtedly present and had been for an extended period of time. The evidence needs, of course, to be assessed as a whole, but a revealing part of Mr. Gray's evidence was to nearly admit in response to questions from you that he had removed the Potemkin Theatre as a reaction to service of the enforcement notice. What he said when asked that question was the enforcement notice informed the changes that were made. Similarly, in relation to HVAC, that was present and had been for an extended period of time. Both structures were put to uses related to the overall use of the planning unit, albeit not the lawful uses of the planning unit. Both were affixed to the main buildings. Both were intended to be safe, to be capable of use by people, one for habitation or for people to enter and view, and the other for entertainment. Both were substantial structures. And the evidence of Mr. O'Connor is compelling in relation to why those structures are operational development for the purposes of the Act. He applied the conventional case law on the definition of a building to reach the conclusions he did, considering the issues of size, permanence, and physical attachment, and using the examples provided by the case law as a sensitivity test, and I've recited some of those examples. The answers to these questions are clear, not just on the balance of probabilities, but beyond a reasonable doubt. And so there is no merit in the ground C appeal in relation to those two structures, and as per Mr. Gray's proof of evidence, no ground C appeal is pursued in relation to the other structures that are subject of the notice. The pursuit of this ground of appeal was unreasonable. There was no effective challenge to the council's case during the inquiry evidence, and as we know, the onus on a ground C appeal is upon the appellant. So I turn next to ground F, which can be dealt with shortly in light of observations that you made during the course of the proceedings, sir. The purpose of the 2019 notice is to remedy the breaches of planning control. Mr. Gray's evidence relates primarily, if not solely, to questions of amenity which do not go to the purpose for which the notice was served. No lesser steps have been identified that would actually remedy the breaches of planning control set out in the 2019 notice. And so you indicated clear views, as I say, as to the purpose of the notices from the outset of the inquiry hearing, and no substantive case has been raised to displace those views. No challenge was, in reality, raised, and pursuit of this ground of appeal in the way that it was pursued, therefore, from the outset was unreasonable. In relation to ground G, no good reason has been given as to why the remaining structures could not be removed within the period allowed by the notice. It provides a reasonable period for compliance, and no reasonable detail has been provided as to why a longer period of time would be required. And so we say again, the pursuit of that ground was unreasonable on the evidence before you. So I turn to ground A, and so I've identified in paragraph 21 the main issues you identified in relation to ground A. First of all, the effect of the appeal development on the character and appearance of the conservation area in the setting of neighbouring listed buildings. Secondly, the effect of the appeal development on the living conditions of neighbouring residents. And thirdly, if there is harm arising, whether the harm is outweighed by public benefits of the appeal development so as to justify a grant of permission. And the relevant local plan policies are set out in the evidence, but they include LP1, which requires development of the highest quality, and policy LP3, as we will recall, protects heritage assets in particular. In judging the ground A appeals, the decision letter of 2017 provides both a useful framework and, we suggest, sound views expressed in relation to the structures and approach being dealt with under that earlier enforcement notice. And so we recognise at once that you will form your own views on these issues, but it is noteworthy, we say, that the framework approach and those sound views with which we suggest you should have sympathy have not been grappled with by the appellant, despite the enormous volume of evidence that they have produced to this inquiry. So while you will form your own views in relation to these planning issues, in relation to Mr. Froman's evidence, where that comes into play, we say it is right to note a few features of that evidence. Firstly, despite repeated requests, there has been no disclosure of his material instructions. Now, this morning, just to update that, this morning I've been given one email, so which I doubt
Sorry, you've been given
one email, which I doubt you've seen, which purports to contain at least skeletal instructions from Mr. Gray to Mr. Froman. But as I understand the position, firstly, it's not before you. Secondly, the chain of communications relating to those instructions are not before you. And so I maintain this point. I say that the failure to disclose material instructions is inappropriate and unreasonable in any circumstances, but still less in circumstances where we know an expert witness had, long before his actual instruction, publicly expressed final views about his strong support for the proposals subject of the inquiry. And so by Mr. Froman's letter of the 7th of October 2020, he did provide clear and unequivocal support for the proposed development, and that was a detailed letter of support made many months before his instruction. Third, Mr. Froman was, prior to his instruction, approached to act on the judging panel for Anti-Pavilion. He accepted that invitation in February 2021 and was a judge in the process. As it transpires, he gave his support to tensegrity within that competition. In those circumstances, the ability to review and form an independent view is, objectively, we suggest, compromised. And fourthly, consistent with all of that, elements of his report do amount to pure advocacy. And so if you need to look for examples of that, I suggest they can be found in the references given there within his proof of evidence. Following on from those comments and the comments about the inspector's decision letter in 2017, if at that stage one structure, Beach House, was incongruous and not in harmony with its setting in this context, then the plethora of buildings that Mr. Dyer identifies, we suggest is inherently likely to cause greater incongruity and harm. And so I turn to the effect on character and appearance, including on designated heritage assets. So first of all, we just remark that the statutory duties relating to designated heritage assets are well known, and so I don't repeat them within these closing submissions. But for the reasons set out in Mr. Dyer's proof of evidence as supported by Mr. O'Connor, the developments have caused harm to the complex of buildings, the conservation area, and Haggerston Bridge, and to a lesser extent, as per Mr. Dyer's evidence, they also cause harm to Queensbridge Road Bridge. Mr. O'Connor summarises the position of the conservation area within his evidence. I've given the reference there. It's a well-used public space with an important environmental landscape, and it also has a unique industrial heritage, including the locks, bridges, and moorings, and in the industrial buildings beside the canal. And so against that assessment within the conservation area materials, I go on to summarise Mr. Dyer's evidence on these points, and he noted the following matters. Within the conservation area, there are a number of flat-roofed former industrial buildings which are characterised by their flat roofs and often 2-3-storey in height. A key character is therefore the flat roof. In cross-examination, he noted that where the historic buildings survive, they are 19th, 20th century industrial wharf buildings by and large. He pointed out that that is why the conservation area moves along the canal. In relation to the Potemkin Theatre, he said it was in a highly visible location, clearly visible in long views, uncharacteristic, bears no relation to the industrial character of the predominantly brick host building, fails to pick up on the limited palette of traditional materials of the conservation area, such as brick and tin roof, and its sheer height compared to the host building simply added to the incongruity. In relation to Wickle House, he noted a design and innovative use of materials, but went on to say that his view was that it resembled a shed on a roof as an ad hoc addition. It was highly visible from the canal and sat jarringly on the host building. In relation to HVAC, he noted its current state as being haphazard, dilapidated, and not an example of high quality design. In relation to the metal shed on the roof, again, uncharacteristic form of development, ad hoc, fails to relate to the host building and the wider conservation area. And he was clear in his view, despite cross-examination, that there were no public benefits arising from these ad hoc structures. In relation to the green wall, his view was also the green wall was out of character for the conservation area and an incongruous treatment. It does not appear, as a matter of fact, to be flourishing even 5 years on, and its impact is to make the host building appear worse. Mr. Dyer did not accept the criticism of the officer report, referring to the Potemkin Theatre as comprised of low-quality structures. From his site visit, he described the structures as being, by their nature, made of utilitarian standard, off-the-shelf timber panels, painted canvas, and done in a way that was normally indicative of cheaply made structures. And so that was his assessment, as it were, as someone looking at Potemkin Theatre would see it. Now, sir, we say in policy terms that any harm to designated heritage assets has consistently been required by national policy to be accorded great weight, and you can see that through the evolutions of the MPPF. That requirement is most recently reflected in the MPPF 2021 at paragraph 199, and any harm to the significance of such an asset requires clear and convincing justification. And so we suggest, this is one of the authorities that I've added, but it was something that was actually referred to by Mr. Froman in his evidence. We suggest the correct approach identified by Mr. Froman in the Lady Hart case, and I quote very briefly from paragraph 40, Mr. Justice Sales, as he then was, now Lord Sales. The MPPF created a strong presumption against the grant of planning permission for development, which would harm heritage assets, requiring particularly strong countervailing factors to be identified before it can be treated as overridden. And the ability to weigh in the balance public benefits is confirmed by paragraph 202 of the MPPF. However, the ability to afford any positive weight in this case is hamstrung by the absence of the clear and convincing justification. The evidence given in support of anti-pavilion as a competition lacked objective material supporting it. Rather, it was attempted to be supported by a bandwagon of former winners, judges, and a witness of a previous sponsor who has withdrawn their sponsorship. Their subjective evidence waxed lyrical about the competition, but did not provide proper objective detail about, for example, how it supports those who would not otherwise be supported, why it is necessary for the display of art to take place at that location, the scope of the benefits, bearing in mind there is one annual winner of a modest prize, and so on. At numerous times, the evidence was hyperbolic, and I've given some examples. None of those witnesses carried out any heritage assessment or analysis, or took into account the statutory duties placed upon you relating to designated heritage assets, or indeed national or local planning policy. In stark contrast, the inspector in the recent 2017 appeal found the structures then in question were incongruous, not in harmony with their surroundings. In that respect, explicit findings were made that the structures as a whole should successfully harmonise with the design, character and appearance of the wharf. The concept and requirement of harmonisation is a well understood one within conservation areas. In dealing with the building complex, that inspector considered the structure was an incongruous rooftop appendage to a commercial building prominently located, and I've given a number of references to where observations that we say are, as it were, at least informative, can be found within that decision letter. In dealing with the conservation area, the inspector noted that the conservation area by the appraisal has a unique industrial heritage, both along the canal, including the locks, bridges and moorings that I referred to earlier, and in the industrial buildings beside the canal. Later in his decision letter, he drew further attention to the specific features of the conservation area and noted still later that they are capable of applying with even greater force, or I would say that his observations at DL 41 are capable of applying with even greater force, and to borrow some colourful language that was used in the Architect's newspaper in relation to the development that is before you, the Mad Hat menagerie of quirky architectural interventions. Or if you prefer, the more measured tones of Mr. Dyer, where he referred to the ever-growing plethora of increasing complex and random structures that have no relationship with the Regent's Canal or the host building, which are now present. And it is a notable feature of the appellant's written evidence, at least, that it does not suggest with any force that the structures harmonise with the conservation area. So the 2017 inspector concluded that the adverse impact of the incongruous structures diminished the contribution that Columbia Wharf makes to its historic surroundings. Now, in relation to Hoxton Bridge, the volume and number of interventions means that there has been a detrimental impact on that designated heritage asset setting due to the fact that structures 1 and 2 in particular are highly visible from the towpath of Regent's Canal and on long distance views on Hoxton Road. And the significance of the bridge derives from its relationship with the canal, towpath and nearby buildings, and I've set out some of Mr. Dyer's evidence on that point in the footnote. The appellant's point about Ron's eel and shellfish, which came up from time to time, is a bad one for the reasons that were given by Mr. Dyer. The advert was put in place prior to the conservation area, and in a later application for consent, the officers were simply concerned to avoid the granting of permission for a vinyl wrap, because that would not have been sympathetic. It would have flaked and peeled away. It has no real bearing, Ron's eel and shellfish, on the acceptability of rooftop art installations. So finally, on this point, on the heritage evidence, we say, for the reasons I've already given, that where there is a conflict between the expert witnesses that you find it necessary to resolve, and Mr. Dyer's evidence should be preferred, And I turn next to the issue of impact on residential amenity, which under this appeal we deal with briefly, because we submit that the harms in relation to residential amenity under Appeal A really flow from the heritage harms identified above, together with the issues in relation to visual amenity that Mr. O'Connor identified. And in relation to the public benefits case, sir, I've addressed that directly below in relation to Appeal B, so I don't see anything more about it in relation to Appeal A. But before turning to Appeal B, the last feature I would notice, sir, is a concern that you raised and that I think was shared between the parties, and that's the operation of Section 75, subsection 3 of the Town and Country Planning Act. And so, as we know, the operation of Section 75.3 confers use rights based on design for a building which is granted planning permission. And in this case, that has relevance for both Whittle House, a dwelling house by design, and the Potemkin Theatre, which, as Mr. O'Connor explained, is advanced by the appellant on the basis that the cinema is integral to the structure. It also has potential relevance for HVAC, where the design purposes of the structure are less clear. As Sir you pointed out, Section 75.2 is not available in these circumstances as a means of control, because it would require amendment to the description of development, which is fixed by reference to the allegation made in the enforcement notice. So, sir, for the reasons that are expressed there, we say that Appeal A should fail, and I turn to Appeal B, the 2020 enforcement notice. Now, that enforcement notice was made, sorry, forgive the typographical error there, it should be 2020 notice, made on 28th of August 2020. And as both you and Mr. O'Connor noted, it's a mop-up notice to catch objectionable uses which may not result in further operational development, and that's done partly in light of the considerable enforcement history at the site. It may have represented an evolution in the Council's approach, but as you noted, sir, that is perfectly reasonable and to be expected where appropriate. So before turning to the grounds of appeal under this notice, it is important to consider the planning unit under discussion in a little detail. Of the planning unit is a matter of fact and degree, and so a planning judgment, so one for you to make. The cases are clear that it is not an exact science, and I turn first to consider the geographical area of the planning unit. So the revised plan proposed to be attached to the enforcement notice reflects the up-to-date evidence on that. We can access it, we can also permit others to access it. And in his evidence, Mr. O'Connor made it clear that there were two separate extensions to the planning unit in this respect, firstly by air draft and secondly by sharks. The addition of the residential use I turn to next. And so we say that subject to one potential exception, there is no reason here to depart from the normal rule that the unit of occupation will usually be the planning unit. The potential exception is the use of the two dwelling houses, as per Mr. O'Connor's evidence. However, the precise nature of the use of those two units remains, due to non-disclosure by Mr. Russell Gray and Mr. Harley Gray, more opaque than it should be. Mr. Harley Gray did not disclose until cross-examination his occupation of one of the units. He appears to occupy as a caretaker and so as something akin to a C3 use. The occupation of the other unit remains unclear and no tenancy agreements and so on have been produced. Therefore, there is no robust basis for saying that the units, even during periods of occupation, are outside the control and substantial occupation of the landlord, the appellant. Further, whilst the units are capable of having a functional relationship to the larger building, and appear to have been designed on that basis, any such functional relationship did not appear during site visits, or indeed in the evidence. So looking at the evidence overall, Mr. O'Connor was of the view that there was no evidence of the properties being live-work units, and they should be characterised as independent dwellings, being self-contained and satisfying the Gravesham tests. The council accepts that they are. But there is an important consequence to that change. The addition of the residential use, applying the Beach case, marks another event which restarts the enforcement clock. I'll explain Beach in a little more detail later in these submissions. But that is because it amounts to a material change of use, to the mixed use. Subdivision of a residential unit is deemed to be a material change of use of each relevant part of the building by the statutory scheme, in particular section 55(3)(a) of the Principal Act. In those circumstances, introduction of a wholly new residential use, we submit, will normally amount to a material change of use. And so I turn next to the extension of the planning unit and Mr. Gray's evidence. Mr. Russell Gray was not clear in his answers concerning the anticipated duration of sharks, absent, of course, the issue of injunctive relief. In his evidence, he said 2-3 weeks or 2 to 3 months. They wouldn't get to next summer. That's my note of his evidence. And on that basis, it's clear there was a material change of use occurring in that area. It was not being used for purposes ordinarily incidental to the use of the canal. Rather, it was being put to a different use, which was capable of having an impact over a wider area than the immediate area occupied by the vessel. And next, I turn to the uses of the planning unit across time. And so quite a bit of evidence was given on these issues, and I don't intend to do more than summarise some of the key elements of the relevant changes. At first, it's clear from Mr. Russell Gray's own evidence that the level of use for art display fluctuated very substantially over time. It appears to fall broadly into 3 periods. The pre-Arts Foundation period, where Tannery Arts and Drawing Room took place 2003 to 2011. The Arts Foundation period, secondly, 2011 to 2013, and then we have the transition years, 2013 to 2016, also under the Arts Foundation, where there was clear reference to limited and sporadic programming. And then thirdly, the ante-pavilion period. So I turn firstly to the Tannery Arts period. And that period is initially characterised on Mr. Gray's evidence by small-scale intermittent exhibitions by an individual artist or two. He has no documentary evidence to assist with whether this use was any more than de minimis when put alongside the permitted lawful use of artist studios. And in cross-examination, Mr. Gray accepted the evidence for that period was very thin. Mr. O'Connor described the gaps in the drawing room programme as huge, involving gaps of up to 210 consecutive days. According to Mr. Russell Gray, that use commenced in 2003. However, even taking that evidence at its height, the first exhibition did not take place until May 2013. 2 3-month gaps arise, sorry about that one, in 2003, June to October, and November to February 2004. In 2004, there was a 6-month gap, March to October, and if the 1 day of activity on the 14th of October is taken as de minimis, then the gap increases to 10.5 months.
Just a second, sorry,
yes.
Is there a typo there in that?
In A, yes, 57A, yes, that should be a rise. Or
sorry, that wasn't the one I spotted. It was you've got May 20.
And so I had read B, unless you'd like me to read it again. And then in relation to C, in 2006, there were 2 gaps exceeding 3 months, and I've given the dates of those gaps. And in 2007, there were gaps of similar duration. And on the basis of all of that, Mr. Gray was driven to accept in cross-examination that for this period of time, he had no specific or precise evidence demonstrating continuous and uninterrupted user. And Mr. O'Connor was clear about the insufficiency of the evidence for both this period and the Arts Foundation period. And accordingly, we say Mr. Russell Gray's evidence cannot satisfy the Thurrock and Islington tests, which you'll be well familiar with. And moreover, there is documentary evidence about the uses claimed for the building over this period of time. They're found in the planning applications, which Mr. Russell Gray accepted in cross-examination. He would probably have taken time and care to scrutinise. He said, when we had a discussion about this, his eventual answer was, "I'm very likely to have ensured the accuracy of the planning applications." The relevant planning applications are set out in Mr. O'Connor's addendum witness evidence, dated the 28th of August 2020, that was before Mr. Justice Murray and was produced by the appellant as part of inquiry materials. Accordingly, it has been there to be answered by the appellant at all stages. The appellant does not and cannot explain how so many key entries in the planning application history could be wrong, and that is because they are not wrong. The appellant understood, just as the local planning authority understood, that the display of art taking place during that period was low-key and not a primary use in its own right. As Mr. O'Connor explained, the primary use as artist studios could have been left undisturbed by displays by artists not in residence, so long as it did not cross the threshold to become a primary use in its own right. So that deals with the tannery arts part of the history, and I turn to the Arts Foundation. And the Arts Foundation period, on Caroline Rolfe's candid evidence, was substantially comprised between 2013 and 2016 by intermittent periods of display. Accordingly, there were 4 years of limited and sporadic use, which Ms. Rolfe accepted in cross-examination, could be properly contrasted with continuous and uninterrupted as a proposition. And this period included many significant gaps, including 7 months between August 2013 to March 2014, and no realised projects at all in 2015. The gap on that occasion was December 2014 to May 2016. As set out above, she accepted in terms that a reasonable contrast to her description for the use of display of art as limited and sporadic was that it was not continuous and uninterrupted. And so again, applying the Thurrock and Islington tests, we submit that is fatal to the Ground D case unless the 10-year period could be demonstrated by sufficient proof, as at that stage, applying the Ocado test. Now, Mr. O'Connor did not accept that having empty space nominally labelled as for use for future displays meant that there was a display of art which could count towards the period for immunity. He has clear support in that view from the Islington case, where a period of repairs to residential accommodation was held to be legally irrelevant and not capable of contributing to the requisite period for immunity. Mr. O'Connor contrasted use for display with efforts of curators to display art. Similarly, as Mr. O'Connor pointed out, intention to resume an authorised use is not the same as putting premises to the unauthorised use. The levels of use in 2011 appear to have been de minimis. Ms. Rolfe accepted that an event in 2011 had attracted an audience averaging 10 a day, and that was a significant rise in visitor numbers. In that case, the numbers have been achieved by free entry that was widely publicised. Hoxton Docks, as a different adventure, marked Mr. Harley Gray's involvement in the building during 2011. Another feature, therefore, of the Arts Foundation period was the nightclub night party use managed by Mr. Harley Gray as Hoxton Docks. That started in 2012 and so commenced before the appellant, even on their own case, could hope to demonstrate 10 years of art display as part of a mixed use. That is because the earliest date put forward for that purpose is 2003. And that in turn is because, as Mr. Russell Gray accepted in cross-examination, there were no exhibitions at all at the premises during 2002. And Mr. Harley Gray's evidence here lacked any reasonable level of helpful specificity and was devoid of supporting records or proper disclosure of documents. The substance of the use only emerged during cross-examination. At all events, it involved hundreds of people, between 300 and 450 according to the TSN that was served, arriving at the building for parties late into the night. They were paying for entry and doubtless drinks and so on thereafter. The evidence confirms it probably happened on at least 3 to 5 occasions. The purpose of the events was to make money. That use was sufficient for the time during which it was active to change the mixed use occurring on the premises in a plainly material way. Accordingly, it caused a material change of use in its own right, and further, there is no indication in the evidence that it would have stopped apart from the enforcement action taken against it. And so I move in terms of periods finally to the ante-pavilion period. And the ante-pavilion period consists, on any reasonable view, of a substantial intensification of what had gone before. The intensification manifested itself in a number of ways that had planning consequences. And of course, consideration of off-site effects is plainly material for these purposes. And those ways included opening nights or weekends, which attracted up to 1,000 attendees during a concentrated period of time. My note of Mr. Gray's evidence in cross-examination is that he accepted that happened in 2017, 2018 and 2019. Second, the initiation, marketing and carrying through of an annual competition, the ante-pavilion, for the display of art on the roof space of the building. The competition attracted entrants from elsewhere, and there were no relevant limits as to who could enter. Thirdly, the use of the substantial roof space for display of the installations and for various uses relating to the entertainment, including the cinema use, restaurant and bar. As Mr. O'Connor said, all the rooftop displays can be considered to be an iteration of a primary use for display of art installations. It represented, in his view, the dedication of the entire roof space, save the residences, to that and related uses. Separate to all of that, it's worth noting, you remember Mr. Russell Graves asked about this in cross-examination, the older decision letter of the 3rd of February 2015, dealing with the planning application that was made. In that decision, the inspector recorded the use of the appeal premises as then defined, and that was the northwestern corner of Columbia Wharf being used for storage of building materials. And so having sketched all of that out, I then turn to what we submit is the effect of a material change of use of the planning unit during the relevant period. And we say that such a change will normally extinguish previously lawful uses, even those authorised by planning permissions. I've given authority for that, that's Stone and Stone, and I've given the paragraph references that are most important in relation to that. And then, as it were, moving closer to home, but consistent with that, where a new use is introduced into an existing mixed use, the question is whether new use D, and this is an example taken directly from the Beach case, new use D, creating mixed use A plus B plus C plus D, amounts to a material change of use compared to the pre-existing position of A plus B plus C. If it does, then the enforcement clock restarts. And so when you have the chance to review it, you will see that is a direct application of the statement of law contained in paragraph 18 of the Beach case, where clear guidance was given in relation to this matter by Mr. Justice Ousley. And given the appellant's reliance on Ocado, forgive me just a second. Given the appellant's reliance on Ocado, it is important to note a few features about that case. Firstly, Ocado was not a mixed-use case and therefore was not required to and did not address the point that Beach decided and or the categoric statements of principle made by Mr. Justice Ousley in that case. B, doubtless for those reasons, Beach was not cited, discussed or found to be plainly wrong in Ocado. And so you may immediately see the relevance of those words, but I go on just to remind us all why that's the relevant test. The plainly wrong test would have been the appropriate test applying the rules of precedent, because both decisions are decisions of the High Court. And so if the High Court's going to depart from a previous decision that was made, judges will only do so on the basis that they think that that decision is plainly wrong. In short, nothing in Ocado affects the impact of Beach. And so applying that principle to the evidence and bearing in mind the onus of proof upon the appellant, the inevitable conclusion, for reasons I'll turn to develop very shortly, is that the ground D appeal in Appeal B should fail. But I take now the grounds of appeal in the same order as I did for Appeal A, turning first to ground B. The allegation, as amended, is a mixed use with various parts. Each of those parts has occurred on the evidence. The requirement of an appeal under ground B is to demonstrate that those matters alleged in the notice have not occurred as a matter of fact. But in fact, the way the appellant appeared to address both grounds B and C, and I've given some references to Mr. Russell Gray's proof of evidence is to allege firstly that there was a lawful use for the display of art installations, and secondly that all of the other uses were ancillary to that. Properly understood, we submit that's not a ground B appeal, but a ground D appeal. As to the restaurant and bar, which are to be read together in the notice as we discussed, the appellant's own case is that a restaurant was operating in the period 23rd of July through to the 3rd of September 2020. Accordingly, it was operational before and during the issue and service of the enforcement notice on the 28th of August 2020. In the case of a mixed use within one planning unit, it is nonsense to say a restaurant must be open for a period greater than a number of weeks before it can be regarded as more than de minimis, and therefore a use of the unit would be added to the mix of uses. It was not ancillary or incidental to any other use. It had its own operator, staff, hours of operation, and clientele. Mr. O'Connor was able to hear it and see it from the street. It was plainly material in terms of its planning effects. And as you commented, the idea of permanence is not relevant, is not the relevant point in this context. What is relevant is whether or not there is a material change. Additionally, in relation to the restaurant, there was apparently no need to reserve seats in advance. Similarly, people could arrive for simply a couple of beers. That was all in Mr. O'Connor's evidence. And similarly, even if the bar is to be read disjunctively from the restaurant, as to the bar, the appellant's own case is not that there has been no bar use, plainly there has. There were 12 such events at least in 2020. The way Mr. Harley-Gray puts it is that the land was not put to that use exclusively, but the council does not say it was. It was part and parcel of a mixed use. Rarely have so many straw men been set up to be knocked down as in this appeal. In the same vein, the evidence demonstrates the display of art installations. It also demonstrates the hosting of social gatherings and use as an event space. The appellant's case in relation to cinema use is difficult to understand. A cinema was in place. It was being used to show films as well as for other functions. Tickets were available for a price and were bought. The appellant has failed to produce any documentary information about the actual ticket sales, but we know the promoters were seeking to sell up to 180 per performance. It remained in place for a substantial period of time, and it was specifically advertised as being available through the appellant's own promotional material, which remained on the website until the issue of the notice, and on Mr. Harley-Gray's evidence well beyond. According to Mr. Harley-Gray, it was maintained in place with the intention and prospect of further performances taking place, and we know, for example, that Jaws was shown as part of the opening of Sharks. And so for all those reasons, the ground B appeal should be dismissed. Turning to ground C, first, there is no lawful use for the display of art to which anything ancillary or incidental might attach. Second, even if there was, the display of art does not carry with it the ability necessarily as being something that would either be ancillary or incidental. The use of a restaurant, a bar with the benefit of a premises license, or of a social event space. Third, these uses have become, in any event, principal uses of the land at the time the 2020 enforcement notice was served, and so for those short reasons, the appeal under ground C should be refused. Bearing in mind what I set out earlier in relation to the planning unit, we can now draw those observations together in dealing with ground D. And so, sir, we say for the reasons that I've already set out, the ground D appeal should be refused, but I rehearse some of the, as it were, fatal blocks that stand in the appellant's way in this respect. Firstly, the evidence for the years claimed 2003 to 2013 is wholly unsatisfactory and insufficient in relation to a display of art. It is manifestly inconsistent with a series of planning applications made by the appellant or made on its behalf. Second, the parts of the building subject to the 2003 appeal were then in use for storage of various building materials. Third, the evidence for the years 2011 to 2016 shows substantial gaps and limited and sporadic use. Fourth, a nightclub night party use was introduced in 2012, resetting the enforcement clock. Fifth, a residential use was introduced at some time between 1998 and 1999 when works commenced, and 2011, 2012 or 2013. And so I've noted there that those dates arose from the cross-examination of Mr. Russell Gray. That's my footnote 59. I'd invite your attention in due course to, of course, all of the footnotes, but I'm not proposing to read them out at the moment. But that one gives a little bit of further detail about the evidence that was given in that respect. Again, the appellant is unable to say this occurred after 10 years of the previous mixed use being in existence. Sixth, the use of the canal area materially expanded the planning unit and accordingly reset the enforcement clock, applying Stowe. Seventh, the changes which the appellant now alleges to have taken place in relation to Wickle House, so that its use moves from art installation to either residential use or use for occupation by anti-pavilion winners, is again a material change of use. The appellant's evidence is unclear as to when that change took place, but in examination in chief, Mr. Russell Gray said, offering accommodation is the principal purpose of Wickle House. And finally, eighth, the same approach applied to the introduction of the restaurant use in 2020 and to the introduction of the bar use, should that have occurred at an earlier point in time, which on the appellant's evidence, it is difficult to ascertain with specificity. So, sir, before I turn away from ground D, which we say should be refused for those reasons, I pick up briefly a point that was canvassed during the course of the inquiry, and that's whether or not there are exceptional circumstances in any event for you to consider the grant of a certificate of lawful use. And we say, of course, consistent with the case I've already sought to explain, that any certificate is doomed to fail for those reasons. But draw your attention to two other points as well. Firstly, there's a reference in section 1771C of the Town and Country Planning Act to any existing use. And we suggest on a proper construction that must be understood in the light of the Beach decision, and therefore, in this case, the existing use which you would be considering is the existing mixed use. There is, as it were, a danger in trying to disaggregate out the uses for those purposes in an application of section 1771C. We say that it's not intended to and it doesn't operate in that way. But finally, sir, as you identified, and all the parties agree, within this context, there should be an exceptional reason for you to grant a certificate in any event, and we say that no exceptional reason has been articulated or sufficiently articulated on behalf of the appellant. And so I turn to ground A, and so again I identify the main issues that you identified, similar but not identical to those in Appeal A. And then paragraph 83, we say there is no planning justification for the kind of mixed use contained in the amended Enforcement Notice 2020 in the host building. Like the art display itself, it is in the wrong location for the mix of uses enforced against, within the conservation area and in close proximity to listed buildings. It's likely to cause harm to the designated heritage assets set out above, dealing with the ground A appeal relating to the 2019 notice, and we suggest that materially similar considerations arise here. But beyond that, the area of the canal from which the site is principally viewed is heavily trafficked by a diverse mixture of pedestrians, with and without children, buggies, dogs, and so on, also populated by cyclists and delivery drivers, amongst others. As Mr. O'Connor pointed out, quite besides the heritage harm caused, it would be an unsafe area to provide a viewing platform for installations on the building. And as Mr. O'Connor went on to point out, the extent of viewing and how long crowds might be attracted for could be substantially affected by a number of variables, such as the weather, what the installations were doing, whether there were large crowds of cyclists using the towpath, and so on. Later on in his evidence, he noted the prospect for those on the local highway network to also observe the roof installations. And he did not accept that a distinction could be drawn between static and moving installations in that respect, so as to show that static displays would not cause harm. As he said, we couldn't control the popularity of particular pieces of art, particularly controversial pieces could attract crowds. We can't envisage the ways it could be used. And he noted the nature of the different spaces, some comparables that came up from time to time during the inquiry, both the Serpentine and Trafalgar Square. And in terms of policy support, the appellant does not refer to any policy support for such a mix of uses. The potential harm to nearby residential amenity is clear, and such harm would be contrary to policies LP1 and LP2, now adopted local plan. Indeed, the appellant does not now appear to mount any positive case suggesting that planning permission should be granted for, as it were, the full gamut of that mix of uses. Instead, what is advanced is a stripped-down version of the allegation in the enforcement notice for consideration as to whether or not that should be granted planning permission. And on that, three general observations may be made. First of all, Mr. Russell Gray, in examination in chief, made clear that the planning permission sought was for the production and display of art. However, it is clear that if such permission were granted, then the other elements of the current mixed use, such as restaurant and bar use, might again follow up to the point just under which, as it were, they became principal uses in their own right. Doubtless it would be said in future that any such uses were ancillary, incidental to the production and display of art. And in assessing this ground, it is also important to recall that for Mr. Gray, it is planning permission to display art over the whole building, including the roof, or nothing. And Mr. Gray was very clear about this in his evidence. His assertion, but without any particular, as it were, objective evidence to back it up, was that display limited to displays inside would rip the heart out of the commission. It would not be sustainable. And my emphasis, he said, I would not continue to sponsor it. Therefore, there is no prospect of a productive display of art use coming forward in those circumstances, and the benefits said to attach to such a planning permission would simply not arise. Further, in terms of art installations upon the roof, a grant of permission under A is wholly speculative as to the merit, on the assumption that it's otherwise concluded there may be some, because it cannot address the operational development aspects of what may arrive in the future, or their potential impact on heritage assets. Any such structures which amounted to operational development would require planning permission, which also assumes a willingness in Mr. Russell Gray to apply for such planning permission. And so against those general observations, I summarise the evidence on behalf of the Council in the Ground A appeal. The key evidence for why Ground A should be refused is set out in the witness statements of Mr. O'Connor and Mr. Dyer. Their evidence was not undermined to any real degree, we suggest, during cross-examination. And the short point is that there's no policy support in the local plan for the proposed development. Mr. Russell Gray did not seek to provide any policy analysis in support of the appellant. Bearing in mind the amount of material deployed, that is a remarkable omission. The proposed development is contrary to local plan policy dealing with town centre uses. LP10 requires use in identified centres or a highly accessible area. The location has a P-TAL measurement of 4 and accordingly is not highly accessible, in Mr. O'Connor's view. And Mr. O'Connor did not accept the proposal could fall within small scale where the plan uses those terms. And the appellant, it appears, does not suggest it does either. The proposal is also in conflict with policy LP38. That policy addresses evening and nighttime economy uses and requires that there should be no negative impact on amenity to adjoining or adjacent residential accommodation and non-residential uses. The development has given rise to a number of complaints as explained by Mr. O'Connor, and that residential accommodation, of course, includes the 2 lawful units in the building, which will inevitably be substantially affected by the proposed uses. Now, turning therefore to the other side of the coin, as it were, the gravamen of the appellant's case in other material considerations relates to the provision of public art. And both Mr. O'Connor and Mr. Dyer addressed that case. On analysis, there is no positive case. First, the location means that the harms that arise are those caused by the display of art and related activity, and it is not double counting harms to acknowledge that fact. Second, Mr. O'Connor was clear that, therefore, in many respects, disbenefits arose directly from that display of art in this particular location. Third, insofar as the appellant's evidence on the point is concerned, Mr. O'Connor remarked about the intangible nature of the claim benefits and considered that the claim benefits had not been demonstrated to have materialised. He referred to much bluster or hyperbole in the appellant's evidence on this point. Fourth, the activities do not fall within public art. It is public art, properly so called, that the local plan seeks to foster. Placemaking is a public endeavour involving consultation and collective decision making. On the other hand, what appears here is rather private art, chosen by private individuals for private reasons, the benefits of which are conjectured upon rather than substantiated. Mr. Dyer commented in cross-examination that the installations don't engage, they are not accessible, they don't tell you anything, they are random structures on a roof. He summarised the benefit as being for the benefit of a small minority of artists. Continuing, I don't see the public benefit in this location. In re-examination, Mr. Dyer expanded on the lack of engagement, noting that the absence of engagement left the structures without connection to the locality, that there had been no engagement with the local community, but rather the structures had been parachuted in. He noted that the jury also does not engage with locals, leaving the impression of the importation of art installations by a liberal elite. There are no demonstrated other material considerations in all of those circumstances to outweigh the clear conflict with the development plan. So, sir, for those reasons, we submit the Ground A appeal in Appeal 2 should be dismissed. And so lastly, but very shortly in relation to Ground F, for the same reasons that we have set out above, we say that there are no lesser steps that have been identified to you that will remedy the breach of planning control. So, sir, those are the closing submissions on behalf of the local planning authority, and we invite you in due course to dismiss the appeals. Thank you.
Thank you, Mr. Beckland. Mr. Cottle. Thank you. Before we begin, I'm just going to take a very short adjournment for 5 minutes. A quick comfort break. Come back at 11:55.
turns out that we do actually have somebody.
It's really too late, having started closing submissions. That's why I asked first thing this morning. Well, I need to resume, but you know, this is the 8th day of the inquiry. So, what's your interest in this case? But I've now heard the council's closing submissions. So they're not going to be able to respond to anything that's said now. Sorry, may I ask who you are? Monica? Sorry, P-A-R-A? Yep. W-S-K-A. And have you provided written submissions? Well, I'm not going to turn you away, but it just does put me in a very difficult position, having just heard the council's closing submissions, because I really should have heard from any interested parties before then, which is why it was one of the first things I asked this morning. So what is it that you want to say?
What I wanted to say is that and I had to, as a resident, that I'm proud of such a place being there. And then the other thing is that they mentioned buildings, listed buildings. And on the other side of the road, we have the Hoxton box, which has been neglected and is standing there unused for at least 12 years, as far as I know. And having someone looking after this building, very good. And also, throughout the past year, there were some events which, for me as a resident, they made me proud that I lived in such an interesting. Also, last summer and throughout the lockdown, there were some events and people couldn't from the canal, which I think it was very beneficial for only residents, but everyone. And then the structures are green. There is a lot of greenery, and that makes the area look very, very nice. Because I can't ask questions. Shame for structures to be and the place look. Definitely about the recent erected structures, the towers. I think it's very, very good idea, and every time I walk past it every day. It is out to look at it and know that there are people are so smart, so clever people to know. And in the evening, when the lights are on, it looks amazing. Sometimes I just go there to it makes the area look really nice.
Okay, thank you. Have you signed the attendance sheet? Have you signed the attendance sheet? Thank you. Mr. Beglan, I need to check. Is there anything you wish to comment on what you've heard?
Sir, no, thank you.
Okay. Right, Mr. Cottle, are we ready for the appellant's closing submissions? The pile of documents that you have put on the desk. Right, thank you.
Not let all the other issues fall to your whether you consider the internet shops and store them. During the time before shops, none of those alleged harms arose from their presence at the dockside. In ground acre, so the shark can temporarily be introduced. Whether or not it should be planning permission to use the room for more space space for award-winning, non-commercial, self-built experimental installations. Use of a flat roof consistent with use of the roof and external areas for showcasing such displays is the linchpin. Those displays broadly linked and add an obvious sense of vibrancy to the appeal site. Static displays, as opposed to performance art using photographs during that, also need to be distinguished. And here, just to pause, I don't know if you've got handy the appeal statement for December 2020 for the combined appeals that you saw, but I'll just remind you of it, because on the front of it was a picture of ducks, ponds, and aircraft behind.
Obviously loath to interrupt my learned friend, and I only do it for procedural reason. He doesn't have his microphone on, so I'm told that he can't be heard over the live stream.
Thank you. And the point is that there's a photograph on the front which shows the sharks in position.
This is the joint appeal statement front cover.
That's right, yes.
The one with the line of swans on it.
That's it.
Yep.
And what I would like you to do is just to compare that with the fourth photograph, which is a picture of the ballet, which I actually have here. It's the
I recall seeing it, yeah.
And what I'm asking you to do is to distinguish in between sculpture, so to speak, and canal side ballet. Static displays, as opposed to performance arts using the towpath as the viewing gallery, also need to be distinguished. Conditions, and the appellant offers a 106 obligation. If required, in order to ensure maintenance of the green wall, the appellant would be willing to enter into a section 106 agreement in the terms of the draft that can be submitted in the next 14 days. Now, I have a draft prepared. Obviously, it would need to go to solicitors and then it would come to you. But for example, a planning condition that requires the appellant to maintain and not to remove any plants, and or find if they're dying, severely damaged or diseased, you must replace them, is an obligation that is a workable planning condition. But if you were worried about the conditions that you've seen in this case that Hackney have used on Art House in October 2016, you were given the terms of suggested terms. I submit that it could be bolstered by a 106 agreement in terms of the maintenance. You are invited to conclude that the concern over public safety can be met by conditions. That alleged concern formed the backcloth to the local planning authority deciding that whereas display of art installations on the roof had hitherto been ancillary, now there was a different level of activity. They really mean intensification. And intensification was introduced late and not properly ventilated and not put to Mr. Gray. In relation to Ground A appeal, in Appeal B for display of art installations, a time-limited condition is volunteered, permitting a 5-year permission for the appeal site, in addition to existing uses, for display of art installation, would leave both the significance and setting as defined in the MPPF of the bridge, and would leave the character of the area, including the conservation area and the bridge, unharmed, or would ensure that any such harm which is denied is less than permanent. Limiting any external art installation to 15 months would mean a different balance of factors falls to be decided. Although no loss of fabric of the appeal site is involved, reversibility can be a material consideration in relation to heritage. And this is an authority that's in your bundle, where it was said by Mr. Timothy Corner QC, sitting as a Deputy High Court judge, it's plain that reversibility of development can be a material consideration, which a decision maker dealing with an application for an alteration to a listed asset is entitled to take into account. A public consultation would take place for operational development that could control impact from height, etc. Air draft and sharks did not involve any operational development, and nor does the 2021 winner do so. The suggested condition would also mean no external exhibit remains on show for more than 15 months, and there's control of external lighting with a 7 p.m. curfew on rooftop use. A time-limited permission would allow further review and give neighbouring residents a further chance to be heard before planning permission for display of external art installations is made permanent. That outcome would be hugely popular, as it would permit return of the much-loved sharks and the celebrated annual succession of anti-pavilion winners. You saw sharks in the Islington Basin, where they caused no harm and none of the risks to the public as Mr. O'Connor alleged they would. They caused joy to thousands of observers and became the beloved mascots of the local school. The city, the site, the conservation area, and the locality. And this is where I refer you to the further document that I handed up to you this morning, which is a draft statement of common ground. Sorry, I do apologise for the staple there.
It means I can't turn the page.
And the draft statement that I've handed up is a document that I just ask you to turn to page 3 of 14. And the submission is this, that the lines that have been deleted were lines that were deleted by Mr. O'Connor. And the site description that's left intact without those deletions, we could infer would be agreed. So that's why I'm endeavouring to put the document before you in order to facilitate your decision. So paragraph 10 of my submissions is see the agreed description in paragraph 2 of the documents as comprising that part of the draft statement of common ground that was provided, not signed by the council, provided by the council. So I need to correct signed in the second sentence of paragraph 10 to provided by the council. You are invited to take into account the significance of the conservation area as a whole and take into account the contribution of its setting in 360 degrees when assessing the impact of the subject of the Ground A appeals. You are referred to the approach of the inspector relied on Mr. Froneman at footnote 4 to paragraph 235 of his proof and agree that the use of views is a useful tool in the heritage analysis. However, it is not an end in itself. And in my opinion, the council made the mistake of being overly reliant on the effect on views rather than considering the effect on significance of the asset overall. This is particularly relevant in relation to the particular conservation areas here because they are extensive and varied in character. This may mean that findings of harm will be more difficult to substantiate. Nevertheless, that is the approach that is required and it must be followed. Extracts from the 2000 and 7 conservation area are attached at the end of the document. And just casting your eye forward, if you would, to the very last pages. I've put at pages 41 to 43. What in my submission are the entirety of the relevant extracts to give you a quick reference guide to the most relevant passages in the conservation area appraisal. Returning now to paragraph 11 on page 3, it says, there is no prevailing building form in the Regent's Canal conservation area. That's at page 44. Today, many wharves and industrial buildings have been converted into studios for the creative and artistic industries that flourish in southern Hackney. Of particular note are studios and galleries along Eagle Wharf Road, and Orsman Road. This is not simply a late 20th century phenomenon, but dates from the 1930s, when a former power station on the canal became the Gainsborough Studios, the heart of the interwarm film industry in Britain, page 42. One of the major uses of the canal today is as a place of recreational activity, it's page 43. Mr. Frohman helpfully took you to page 54 of the 2017 review study for the purposes of what you are judging at the proposal against. We asked why Mr. Dyer failed to carry out a similar task in his proof. And page 54 says, these buildings are not instantly recognizable as of architectural merit. They were constructed as workaday buildings that used industrial materials, and they've often subsequently been altered or extended in a pragmatic manner. These imperfect, cheap, and sometimes shoddily built structures are often fragmented and devoid of their original uses as industry has moved away. They are notoriously difficult to successfully upgrade for new uses without major intervention and are therefore often seen as eyesores. It's further agreed in the draft statement of common ground supplied by the local planning authority that the review study presents the designation as being for the charm and evocation of a former industrial canal site converted by buildings of no consistent style. They've been amended and extended for functional reasons with little regard to the aesthetic considerations in the prevalent materials of low-cost industrial buildings of the day. In relation to the conservation area, the context includes that the appeal site buildings include the kind of historic, ad hoc, shoddy, cheap and pragmatic alterations as per the 2017 study. Art displays on the site, for example, the one previously located on the elevation nearest the Hoxton Bridge, which Hackney wanted to retain, are consistent with the mosaics and other local art installations, along with the historic artistic activity that are a feature of this conservation area. It's worth noting at the outset that part of what you're being asked to decide is if the display of site-specific art installations at the appeal site can properly be regarded as an asset to the conservation area without reducing or vitiating its significance. That was 3.10 of Mr. Frohman's proof. You are invited to agree that is so. For display of art externally to be prohibited when conditioned use is perfectly possible would be excessive. Buildings that make neutral contributions can be redeveloped. The appeal site was apparently included within the conservation area with that in mind, as happened to the Acorn Pub. Look at the timing. The boundary at page 1.2 to the conservation area includes modern housing at Kent Wharf, for which no explanation has been provided. You're invited to find that the appellant has improved the northern projection to the appeal site. The 2000 study spoke of the survival of the appeal site, the future of which will be heavily influenced by the outcome to this appeal. This point is an important point underlined by the role that the holding of events play in relation to the financial viability of the use of the appeal site for display of art, arts studios, and charitable artistic activities. Events at the appeal site also provide visitors with the opportunity to engage with the buildings and to experience the spaces on the appeal site, as well as the art installations on display. The two things are complementary to each other. The buildings, so far as they are valued for their industrial history and the interaction with the canal, only deliver effectively if they are experienced internally as well as externally. As regards the surrounding area, it is contrived for the planning authority to ignore what is next door. Design incongruity is the hallmark of the overbearing Bridge Academy. And just to pause there, Mr. Harper said it was good to see architecture that was trying to do something. Hallmark of the overbearing Bridge Academy, which sets the context to the appeal site and cannot be ignored. The Bridge Academy is a building that is built alongside the conservation area and dominates the character and appearance of the area in which the appeal site is located. It is the product of the complete clearance of the Victorian Board School that stood in its site until I think it was 2005, sir. The Laburnum Street School building was of obvious heritage value, and the appellant campaigned unsuccessfully against its demolition. The Bridge Academy receives no more than a single passing reference. See the last sentence of paragraph 2.2 of Mr. O'Connor's proof in the officer's reports that the planning authority's proofs and its appeal statement. You are invited to find as a fact that the Academy building influences how the appeal site is experienced when approached from the canal. It's further agreed by the council that in 2007, the council gave pre-application advice supporting the complete clearance of the site for a much higher density residential development, 71 flats. And it's our submission that this advice was given on the basis of the existence of the conservation area, although it was only formally adopted a few months later. Planning history and the C3 use. The planning history under paragraph 3 of the draft statement of common ground is agreed. And so at the back of this submissions, I've also got a few pages with, I think it was appendix 24 to your bundles, with all the planning documents with the correct page reference that I indicated would be supplied to you. A table with the page references to the planning history is attached below. The current mixed use falls for your decision, but the C3 use was accepted before the High Court and relied on by the local planning authority in the suggested amended wording of the 2020 enforcement notice. The 1998 permission to use part of the site residentially in its implementation meant that the use was in existence before completion. The straightforward position is that the planning permission attached to the land and once taken up and implemented gave rise to a new situation, which meant the C3 use was in existence before the delayed completion. It's not possible to argue there was a nil use of the premises after the 1988 permission was implemented. The planning unit. It is essential for the purposes of judging whether or not a change of use has taken place and whether a use is immune from enforcement to first identify the planning unit. The reduced extent of the amended plan actually comprises 4 planning units if the canal and each dwelling is seen as functionally and separate, physically separate. The part of the canal shown in the amended plan covers the area for which the appellant has a license from the Canal and River Trust. That area is occupied by the appellant and has plainly been used for display of art installations, and the Ron's Eels mural for 8 years, an air draft for 2 years before the Sharks' abortive outings. And there's a reference to the air draft documents. The canal has been used for the pre-existing uses, has not been used for the pre-existing use or uses, and therefore it is different. That was how Hackney's application to the High Court was presented. Much was ambiguous, uncertain, but the one very clear point was that Sharks was alleged to constitute a material change of use by reference to the London Heliports case. That was not a pointless discussion of the Heliports case that took place in Murray Jay's judgment. On the contrary, it took place because it was a live issue on the basis of Hackney's case. Either the area of the canal shown in the amended plan is deemed to be part and parcel of the same planning unit as the appeal site buildings, or it is not. It is submitted that the canal, for incidental mooring and navigation, is in separate ownership, and the relevant area of the canal is a different planning unit. No one produces art there in the course of their business as an artist. Nobody paints or constructs experimental structures on that area of the canal. Such art production has taken place inside or on the roof of the buildings. Once made, some objects have been moored on the canal for display. If the Ground D appeal or the Ground A appeal in relation to displays of art installation is allowed, and the canal is part of the same planning unit, then different considerations apply. However, first things first, the entire canal is in separate ownership and is a single separate planning unit, and the appellant's use of it for pontoons, mooring the barge ooze which has air draft on it, and the short-lived display of the sharks did not alter the use of the canal. Where flats are being let to separate occupiers, the planning unit should be the flat in question. The 2020 amendment of the use class order. On the basis that the C3 use as residential dwellings takes place in different planning units, and if the Ground D appeal and the both Ground A appeals are dismissed, the former B1C use is now to be regarded as use class E. The associated permitted development rights accordingly follow. If the Ground D appeal or the Ground A appeal in Appeal B are upheld, then there would be a mixed use class, Class E and F1G, and the permitted development rights associated with Class E would not arise. Amendment of the notices. The reduced extent of the amended plan actually comprises 4 planning units, as I've stated. A lack of precision and clarification of the notices. There is a confusion of terminology, especially concerning social gatherings as distinct from events. In relation to Ground D, Hackney reduce display of art to only publicly accessible exhibitions, i.e. when the doors are open. Whereas in relation to Ground A, the meaning of display of art is not so limited. The council has not defined the meaning of art installations. The 2020 notice is aimed at the rooftop installations. After Mr. Connor finishes evidence, you may well have concluded that what swung the planning authority into serving the 2020 notice was the concerns of a change of use of the canal, as they argued in the High Court. It was the public performances, and that's the ballet that I've shown you, the pinch points on the canal, the risks to public safety, and the harm to residential occupiers that the sharks were anticipated to cause, that the council relied on for the injunction, and which formed part of the backcloth to the MCU 2020 notice. There were no adverts for film showings, as alleged in the 2020 officers' report at that time. It turned out the council were relying on stale social media adverts from Twitter. See the last appendix to Mr. O'Connor's proof. Therefore, it submitted that the notice should be amended. The notice should be amended to take out the internal displays of art. The planning authority have scant, if any, reason for opposing such displays if they take place internally. Hence, despite being aware of the activity, since at least 2004, no enforcement action was taken. These points should be reflected by amendment of the enforcement notice accordingly. It is if the language in the 2020 material change of use notice does not properly describe the activity that is complained about, then the inspector should, where there's a proper evidential basis as exists here, choose his own language. The same is true in relation to operational development, e.g. delete the bamboo fence and add to the hatch and the platform as modified. The clarification of the second enforcement notice betrays its invalidity. The second notice was therefore unacceptably uncertain and vague. It's also submitted that the first notice failed to identify that structures 1, 2, and 3 were art installations. The following amendments would clarify matters and are supported by the underlying facts. To amend the first notice so that it refers to structures 1, 2, 3 as being art installation, to amend the plan and the wording to both enforcement notice to exclude the 2 dwellings, both pursuant to the 1998 Planning Permission because they comprise a separate planning unit in the third scenario described by Bridge J in the Birdle case. To amend the plans and the wording to both enforcement notices to exclude the canal because it comprises a separate planning unit in the third scenario described by Bridge J in the Birdle case. To delete the term social gatherings from the second notice because it's too vague. To amend the wording to the second notice as deemed fit or to entirely delete the reference to cinema and or the reference to restaurant bar because it was or they were de minimis and not enough to amount to material change of use. Safety concerns arising from the use of the roof, top external gallery and outdoor performances. You are invited to conclude that it's the outdoor use of the roof space and of the canal that Hackney is most concerned about. In the light of the concern over safety, you're invited to find that there's been no proper risk assessment in relation to the use of the land for art installations, including the use of the roof space as an external gallery for static displays, that could base a reason for refusing the Ground A appeal in both appeals. Mr. Justice Murray addressed Mr. O'Connor's concern arising from perceived risk to safety from a Hoxton Bridge pinch point viewing point. There's no unacceptable risk to public safety from people stopping to take a photograph or gaze or laugh as the children do. The appellant does not accept that static displays cause any such risk, and you are invited to agree. The concern about use of the canal towpath as a viewing gallery has seemingly contaminated the planning authority's approach to valid indoor activities. The case is not about outdoor performances of disc dancing and the opera, but if you feel that it is, then the appeals can still be allowed with a condition that prevents outdoor live artistic performances playing not with the back to the canal, but reaching outwards to a canal towpath audience. If there is such concern over public safety, it can be adequately addressed by condition. Judgment of Mr. Justice Murray. The judgment is relied on to show the need to correctly understand the sharks. You saw them. They did not have and were never constructed to have the lasers that are referred to in Murray J's judgment at paragraph 46(4). The evidence from Mr. Shorten that you received when you read with the judgment demonstrates the exaggerated impression that Hackney were advancing regarding the sharks. And I just pause here, sir, to comment that if there was anything helpful in Mr. Justice Murray's decision that in any way denigrated what the appellants were doing, my learned friend would have relied on it. And we're relying on Mr. Justice Murray's judgment because it does deal with the perceived risks emanating from the sharks. If any enforcement is carried out on such a rash basis as what was said in a newspaper article, then it carries obvious risks. It's elementary that investigation should have taken place. The IT problems the council experienced in 2020 is no excuse for not making necessary inquiries to investigate their concerns. The authority accepts it was aware of the 2020 winter about 4 or 5 months earlier. None of the feared harms subsequently arose. The sharks were in fact empty-headed, as you saw them in Islington, and were devoid of the gadgetry that Mr. O'Connor presented as a threat to public safety or feared, in reliance on the newspaper article, which would cause an unacceptable impact on neighbouring occupiers and users of the towpath. It's acknowledged the emergency without notice section 17B application. The evidence Pavilion 2019 licence application are relied on by the local planning authority as complaints about the presence of the structures. That does not follow. The objections to the appellant's 2019 licence were unsustainable on licensing grounds. The challenge to the art installations on the rooftop was simply a collateral attack on the licence application, purely accusations of inaction on the part of the council. None addressed the structure's aesthetic impact on their surroundings. There is sufficient distance, as much distance as from the Bridge Academy, for any art installations not to have any unacceptable significant effect on neighbouring residents' visual amenity. Potential harm to neighbouring residents' living conditions from events, external lighting, etc., can be met by conditions, including licence conditions. Notably, the council sought the retention of a drinking establishment on the lower floors of the Acorn site with 5 floors of flats directly above. It's agreed in the draft statement to Common Ground that the council supplied that the objections received by the LPA in 2019 were to a premises licence application made for a short programme of events to showcase the Potemkin Theatre when it opened in August and September. It's also agreed that the premises licence was subsequently granted in 2019 after all objections were conciliated. The previous decision letter of Inspector Burrows. There are marked differences between the matters that fall for your considerations and those before Inspector Burrows. He was not considering the planning merits of display of art installations, which are markedly different. The hatch uses the same materials as already on the roof of the buildings, which makes a positive contribution to the surroundings. The railings are not out of place. The fact that Inspector Burrows decided that the beach house did not harm the significance of the baths has not been factored into Hackney's appraisal of how structures that are further away, in the High Court case it was even the sharks, do so. The structure of the decision letter was correctly explained by Mr. Froman, and you should reject the construction put to him in cross-examination. The review study him, he would not have said what he did without reference to the ad hoc alterations of buildings being one of the identified heritage features of the area relied upon by the council for the designation, rather than being out of kilter with it. He was unaware that what he was describing at paragraph 19 regarding evolution in a piecemeal manner was identified as a positive feature characteristic of the conservation area in the study. He was unaware that this characteristic of the site preserves what is identified by the council as positive. Conservation of the designated heritage asset, and that more important, the asset, the greater the weight should be, does not predetermine the appropriate amount of weight to be given to the conservation of the heritage asset in a particular case, which is a question left to the decision maker as a matter of planning judgment on the facts of the case, bearing in mind the relevant case law, including Barnwell Manor, wind energy, and East Northamptonshire District Council. Section identify what is the significance of the assets. You are invited to apply Appendix 11 to Mr. Froman's proof, which sets out the relevant legislation, policy and guidance, and you are invited to share the matters set out under paragraph 6 to Appendix 11. Culture and arts. LP 10. Smaller scale proposals will be permitted in areas that are accessible by public transport and walking and cycling routes by those likely to use the facility. And just pausing there, I heard in my learned friend's submissions something about Mr. O'Connor not accepting that it was smaller scale, but I heard you put a question to him about smaller scale and him accepting that it was. You have to go back to your own notes as to the question you put to him as to whether it didn't, by process of elimination, it wasn't a larger development. Therefore, it must fall into the second category. Because I believe you put that question to him. And benefits from reflection upon public art. London Plan provides HT5, the continued growth and evolution of London's diverse cultural facilities and creative industries is supported, and support the development of new cultural venues in town centres and places with good public transport connectivity. Paragraph 751 says, London's rich cultural offer is important for London's cultural tourism. The vibrancy of London's culture is integrally linked to the diverse communities of the city, and grassroots venues are as important as London's famous cultural institutions in providing opportunities for all Londoners to experience and get involved in culture. See also paragraph 754. Despite this positive general picture, London's competitive land market means that the industry is struggling to find sufficient venues to grow and thrive. Creative businesses and artists also struggle to find workspace and secure long-term financing and business support, as their activities are perceived to be risky or non-commercial value. It's striking that no appraisal under LPT 10B took place before Mr. O'Connor confirmed that use of the appeal site for display of art complies with that policy. Canal side policy. Local plan LP52B states that developments that enhance the value of the water space and makes a positive contribution to the character of the waterfront area and setting. London Plan Policy S16 states at paragraph 916.6, London waterways are often appropriate setting for the public art. I just pause there, that you did hear from a member of the public about it looking nice at night, but there is a picture looking from the top of the appeal site towards the Queensbridge Road with the lights of the building and the installations below, and one cannot help but thinking that enhances the view of the canal. If you look at those nighttime pictures, it's what the member of the public said was a beautiful thing that she went out to look at. Paragraph 68. The failure to assess art installations against that aspect of the policy is also to be noted. Town centres. Hackney's policy LP32 was not attached to Mr. O'Connor's proof. Mr. O'Connor's paragraph 6.54 does not explain why external displays of art would be appropriate in designated town centres. It is a hollow complaint. Nor does his proof establish or allege that use of the appeal site for display of art installations would detract from and so cause harm to the centres listed within Part of A of that policy. Design policies. The policy records that new development will be supported where it respects and complements historic character and preserves or enhances the significance of the historic environment and the setting of the heritage assets and improves the public realm. See also the London Plan. The LPA has failed to assess or seek professional advice from Historic England in relation to the contribution the appeal site makes to the area, as well as to the significance of the surrounding heritage assets. Urban greening. And this is where I wanted to refer you to the further policies that I handed up this morning that are on your desk at the front of your papers. And if we could just turn to this one first, which is Hackney, place for everyone in the Hackney local policy. And this sets out the pages 154 and 155 that talks about living roofs and, in my submission, we're calling about vertical gardens, and the explanation are important. If I could take you to paragraph 11.6 on page 156 of this document. Living roofs and vertical forests are important features of urban greening, providing various benefits, including improvements in the visual appearance of buildings, increased biodiversity, mitigation and adaptation to climate change, and reduction in air and noise pollution. Green roofs can work alongside and even enhance the performance of renewable energy technologies, particularly solar photovoltaic systems, for example, by regulating temperature, and then it goes on to biodiversity. And you'll also be aware that the MPPF, of course, encourages biodiversity. Just turning to page 160, there's reference to LP49, which is green corridors, and there was reference to the canal being regarded as a green corridor. must be developed in a way that contributes to the green infrastructure in the areas of potential new green chains, etc. But I just wanted to pick out the point about green corridors. And then there's a map at 162, which is talking about green chains and open spaces and green corridors. And then there is the London plan, introducing the plan. Do you have this other document? Thank you. And this is the London plan, urban greening. And paragraph 8.51 in the preamble underneath the explanation to the policy, the exclusion of urban greening measures and new development result in increasing green cover should be integral to planning the layout and design of new buildings and developments. They should be considered from the beginning and the design process. And urban greening covers a wide range of options, including but not limited to, and then street, trees, green roofs, and I would underline green walls. And it goes on through the urban greening factor. 855 is talking about residential development places greater demands on existing green infrastructure and so on. And then it has under 8.2 a table which talks about green walls. And over the page, it has a list of notes for H2, and I've got the third document is one of those documents, which is a guide to facade greening, and it talks about the soils and mixtures, supports, maintenance, growth and behaviour, and that the purpose of showing you this is that there is policy support for green walls. That's the purpose of showing you the policy, that they are to be encouraged and they're seen as a good thing, and that's a positive. So I said in paragraph 71 that the policy covers a wide range of options, including but not limited to street trees, green roofs and green walls. And I just wanted to show you those policies. Paragraph 72, you're also invited to also agree with Mr. Frohman that the greenness and the ecological value of the canal is a thread that runs through the character appraisal. This is relevant when considering the effect of a structure such as a green wall. In the context of the character appraisal, it's wrong to infer that green walls should be discouraged in the conservation area. Not all or nothing for ground A. Section 177 does not require an all or nothing approach to ground A appeals because section 1771A provides that grant planning permission in respect to the matters stated in the enforcement notice as constituting a breach of planning control, whether in relation to the whole, and I've underlined, or any part of those matters, or in relation to the whole or any part of the land to which the notice relates, without prejudice to the other grounds. Allowing use of the land for display of art installations that is properly conditioned is a proportionate outcome and would accord with and preserve the public having faith in planning control, being able to reach the right decision with checks and balances in place. If the appellant has temporary planning permission for 5 years to display anti-pavilion winners for no more than 15 months for any external installation and for associated events and has permanent planning permission for internal displays, then that would obviate the need to deal with grounds C and D in relation to display of art installations. And then I set out a table because there was an email from PINS to us asking...
Just before you continue, when you use the phrase internal displays, what are you getting at there? Are you talking about the use for the display of art for visiting members of the public?
Yeah.
So it's essentially an art gallery inside the building.
That's right. And we say that there's no policy objection. And in practice, the planning authority have known about it since 2004 with the compulsory purchase. And no enforcement action has been taken against it. And my own friend's paragraph 60 of his closing submissions seems to infer that it's incidental.
Okay, thank you.
Paragraph 60 said that Mr. O'Connor explained that the primary use as artist studios could have been left undisturbed by displays by artists not in residence, so long as it didn't cross the threshold to primary use.
But you took me to the table.
That's right. We did this in response to a request from the planning inspectorate that we set out exactly which grounds are relied on in relation to which structure. And what I've done in the following submissions is I've tried to follow the order, which is different to my friend's order. I tried to follow the order in that email, which asked us to address the grounds of appeal in order, and that's what I've tried to do. So hopefully this will help you. And may I also comment, sir, that the January 2020, if you could ask to write a note by this, see also January 2020 appeal statement, because the appellant in the January 2020 appeal statement goes through each ground meticulously. It's in one of the appendixes. I'll be able to give you the reference.
Just a moment.
Summary grounds. Appendix 3, apparently.
I'm looking for my own note, which is, I hope, the equivalent of what you've presented here, because it's recorded what I've read in the statement.
Well, if there are some rough edges, I apologise.
Okay, do you want to continue?
Paragraph 76. Operational development, meaning of a structure, and the Supreme Court decision of Dill and Secretary of State. A building is defined in section 336 of the 1990 Act as including any structure or erection, any part of a building so as defined, but does not include plant or machinery comprised of a building. In the Safe Willie case, the court observed it's not intended to be exhaustive definition of building operations, and for the polytunnels in Hall Hunter to remain in one particular location for 3 months was found by the inspector to be sufficient to be a consequence in the planning context. And the judge went on to decide that the council should have gone on to consider whether the construction of poultry units came within the residual category of other operations on, in or over or under land. It's to be noted that the Supreme Court, in the case of Dill, endorsed the threefold criteria of size, permanence, and degree of attachment set out in the Skerritt's case. Permanence was discussed in the Cardiff rating case as suggesting things that would remain in situ and only be removed by a process of pulling down or being taken to pieces. The criteria for art installation of being removable so that they can be reassembled or put up elsewhere is not difficult to imagine. Here, like a sculpture park, the art on display at the appeal site is simply an art installation. The Dill case concerned a pair of 18th century lead urns in the garden of a listed building, which gave rise to the Supreme Court addressing whether freestanding objects such as sculptures might be considered buildings. The case involved a listed building context, but some of the observations were of general application. Having considered a 1,500 kilo Henry Moore sculpture, it was noted that it was a material that the sculpture was an entire object in itself, resting by its own weight on the ground and able to be removed without damage. If an art installation can be brought to the appeal site as one and can be removed intact, there is no difficulty in such art not comprising operational development. If girders are lowered into place to construct a sculpture which comprises a number of parts, which are each separately transportable and possible to reassemble in a different location, that distinguishes the art installation from operational development. In the Barvis case relied on by Hackney, Bridge J, as he then was, observed, "I would be very surprised if the planning legislation did not give to planning authority the opportunity to control this kind of operation. But that was said in relation to an 89-foot crane sitting on a short length of railway track that enabled it to move. And the Skerritts case concerned a marquee put up for months that was approximately 40 metres long and some 17 metres wide, and it was around 5 metres in height. Displays at a sculpture park for which there's already planning permission do not need further planning control every time a new structure is introduced because planning control has sanctioned that development. The same should also be true at the appeal site. Installations of art for art's sake being entirely a product of artistic endeavour for a time-limited period raises different considerations, particularly when the installation can be easily removed intact and moved for showcasing elsewhere. Potemkin. There is an inconsistency given that this structure came down in February 2021. It was taken to pieces and the materials mostly reused. On oath, Mr. Gray said it was not going back up again. Under Appeal B, the planning authority asked the appellant to confirm that no planning permission is sought for a cinema, restaurant or bar. Hackney received that confirmation, and so conditions relevant to restaurant bar fell away. In contrast, the confirmation that no planning permission is sought under Ground A for Structure 1, Potemkin Theatre, that is no longer there, seems to fall on deaf ears. Potemkin Theatre showcase comprised a fortnight of events, and you've got the reference in the proofs. I think Mr. Harley Gray's evidence, and there's also in the documents the programme of events. And the design was based on the waterside still shown on page 134 from Mon Oncle Jacques Tati, 1958, and it's hard copy page 134 or electronic page 165 of 183. It's behind those combined statement. The first document I showed you, sir, was the December 2020 combined grounds of appeal, and it's in the appendices. It has 183 documents behind it, 183 pages behind it, and it's in there 134 hard copy or electronic page 165, and it shows what the Potemkin was based on, which was the Mon Oncle Jacques Tati film and the structure there. Mon Oncle was the opening film of programmes. All listed, Potemkin Theatre served as no more than a suspension point for a roll-away projection screen. It could have been a simple scaffold gantry. This was not a cinema for planning purposes. When enforcement action was taken in October 2019, it was a simple matter to verify that there were no film showings taking place or scheduled, and the temporary seating on the rooftop had already been removed. The documents, see Exhibit L to the January 2020 grounds concerning Potemkin, show the degree of detail that went into the design of Potemkin and shows how wrong the officer's report was in misdescription. Page 134 to 149 and pages 137 to 183 at the back of the January 2020 grounds contain more drawings. The degree of detail that went into the design to make our world better was impressive. See the Reba article in hard copy, page 68, in the PDF electronic page 92 of page 183 of the appendices behind January 2020 summary grounds. Electronic page 96 to 111 show the design detail and the acclaim and the press interest from across the world. And it was the Architects Journal, Dazine, Architects Daily, Chile, Architects newspaper in the States, the Observer, the wallpaper, the Sky Art from Italy, Detail from Germany. And Anti-Pavilion winners are works of well-considered design and considerable craftsmanship, far beyond that embodied in the wharf buildings themselves. They are not randomly selected to provoke, but carefully considered installations that pique interest. The Anti-Pavilion Commission has not become an internationally celebrated annual event for nothing, as the Potemkin documents demonstrate. Wickle House. The Wickle House drawings, see Exhibit M to the January 2020 grounds, show the 8 segments to which the appellant subsequently added the shower wet room fittings. Mr. Frohman's proof at 572 to 532 also refers to it. Submissions on section 75 in response to the note from the inspector dated 17th of September. Section 75, Wickle House was intended and designed as an example of a dwelling having an external, non-traditional, prefabricated experimental form that was placed on the appeal site roof for display only. Since then, the appellant now wishes to use Wickle House as a site facility for the Antepavilion Commission for those working in connection with award-winning installations. Under 75.2, allowing the Ground A appeal can be made subject to condition that specifies the purposes for which the roof or HVAC and or the platform and or Wickle House or the same can be achieved by limiting words, e.g. Wickle House not for residential use save in connection with installations of art display at the appeal site. A register of intended occupiers, as done in other areas of planning control, may be maintained to ensure that Wickle House does not become somebody's only or main residence. HVAC. In its glory, it was regarded as a surprisingly sculptural form. As further described on pages 235 and 238 of Appendix 15 as a pavilion, an expression that was explained to the inquiry by Mr. Harper, disguised as a warehouse duct. A picture of it at night, see page 289 of Appendix 15, shows how, like the sharks, it contributes to the locality. This was an example of showcasing the efforts of young artisans, a recognized charitable purpose that promoted the interface between art, design, and architecture. HVAC is in the process of being taken down, so all that is relevant is Ground G in order for time to remove it. Roof access hatch. Please see the photographs from page 166 of Appendix 12 to the December 2020 combined statement of case. The enforcement notice appeal concerned what was there at the time. However, it would have been possible to impose a condition on the hatch to modify it as presently proposed by the appellant to allow the railings to run continuously along the top of the western elevation instead of stopping where they presently do. The railings, see Inquiry Document 7. See also what is said in the conclusions under Ground F in Appeal B under paragraph 182. Green wall. You are invited to share Mr. Froman's appraisal in paragraph 535 that the canted tops of the green wall structure are less imposing and less bulky than the extension that has been previously permitted, and although very different, adds a new layer to the conservation area that may be regarded as positive in the context of this particular green ribbon conservation area. It looks particularly fitting in views from Swimmers Lane, and the green wall, once established, makes a positive contribution and does not harm the Haggerston bath. And here you do have in the documents at Appendix 26, you'll be able to find them. It's pages 114, 115. Pictures of the green wall. And anybody coming down from Kingsland Road, walking down Laburnum Street towards the appeal site, walking east, they wouldn't know as they pass with the Bridge Academy on their left, as they come towards the appeal site, that they were in any conservation area. And this green wall in that narrow street can only be seen as an enhancement. On top of the buildings, which from Mr. Dyer's point of view are neutral. And you can also see there the separate planning unit of the residential units. So thinking about the green wall in its particular context, on top of the northern projection of the appeal site, can only be seen as an enhancement. And in fact, the MPPF says support should be given to development that includes biodiversity gain. And here you just have to think of how much interest there would be in a well-maintained green wall. And the fact that green walls are talked about in the London plan means that they can be conditioned, even though you express some qualms about the enforceability of conditions. Green walls are being encouraged. They're used by Hackney. You've got the October 2016 condition that they used for Art House, which is in this neighbourhood here. And the fact that green walls are being used and they're being subject to conditions, A, you show the planning authority what is proposed so that the planning authority can approve what's being proposed. B, in that proposal, you emphasize that the roots are in large enough troughs and have proper opportunity of rooting system, as explained in the connecting material to the London plan, so that it's viable. And we have examples from Westminster where there was a green wall in Covent Garden, for example. And that specified what was going to go into the wall. And C includes a maintenance arrangement with a contractor. And so the local authority can see the contract that's been entered into. And D obliges the developer, the appellant in this case, to maintain and ensure that any planting area, Mr. Frohnman talked about a percentage, is replaced. And we are prepared to put that into a 106 obligation, subject to granting planning permission under 177, and have that before you. But green walls can't be thwarted because conditions won't work. Otherwise, green walls would never be possible or be advocated. There isn't a planning inspectorate guide that I know of a model condition for a green wall. There used to be a planning inspectorate guide for model conditions in a number of different situations. But perhaps the planning inspectorate would need to catch up with the emphasis on resilience to climate change, which is encouraging the development of green initiatives at every opportunity. You just have borage and bees, you have flowers, and it's just an enhancement to the local community. Paragraph 93, platform decking. It does not have any effect. Well, just before I leave that, Mr. Dyer seemed to defer to Mr. O'Connor on the impact of the green wall. There wasn't anything particular from Mr. Dyer in his proof about Appeal B at all, and the change of use and the planning application that's being put in the planning application in respect to the green wall. He didn't address that. He seemed to defer to Mr. O'Connor. And Mr. O'Connor hasn't really analysed the policies that support the green wall. Paragraph 93, platform decking. It does not have any effect on the listing buildings nor on the conservation area, and you are invited to allow the Ground A appeal in respect of it. It is shown in Exhibit P, headed Potemkin Platform Measurements to the January 2020 Summary Grounds, electronic page 126 of 183. This has also changed since October 2019 when the enforcement notice was served. In its original form, it did not conflict with any development plan policies. With that platform in mind, you are invited to grant planning permission for a platform that is in condition to ensure that it's in the same position and has all the physical characteristics and dimensions of the present platform. You are further invited to adopt Mr. Frohman's appraisal at paragraph 525 to 6, that the platform, to the extent that it is visible, does not materially change the character of the building, it rather blends in. If it not for the fact that the platform is known to have been a recent addition, it could easily have been mistaken for something that was added to the building many years ago. Further description of each of the above items set out in electronic pages 10 to 12 of the January 2020 Summary Grounds. which appear in Appendix 3 to the December 2020 appeal statement of case. Conclusions on the Ground B appeal. The Ground B appeal is only relevant in Appeal B. The appellant relies on the legal principle of de minimis and says it should be applied for the purposes of allowing the Ground B appeal. Fairness requires that the appellant can appeal on this ground because if the principle applies, it means no development has taken place. And you may feel that all of this can be transferred across to Ground C, but I'm submitting that it can be considered within Ground B. In QuickSave Discount Group and Secretary of State for Wales, a period of 4 weeks use for car sales was taken as a non-user for planning purposes, non-user. The sharks were not there long enough to affect a material change of use, nor was the combined so-called restaurant bar run by Karma Cans. The effect of a de minimis use that has no planning significance, given the surface area of the appeal site, was enough to cause a revaluation. However, it was not enough to amount to a material change of use to either the Regent's Canal or to the appeal site. There are other means of community protection to address the exaggerated public nuisance concerns. And coming back to the picture of the ballet, the disc dancing, it's in the towpath is in the control of the Canal and River Trust, it's their ownership. But it also would be a designated footpath covered by bylaws by the local authority. There would also be police powers, and there would also be Section 222 of the Local Government Act in relation to any public nuisance. If there was a blocking of a footpath, or there was a congregation of people that made it a nuisance, that could be dealt with by other powers. And the one-off disc dancing and opera were not sufficient to occasion a change of use. There are other means of community protection to address the exaggerated public nuisance concerns. You're reminded of the way the planning authority put its case to the High Court and the way the High Court construed the council's case. Restaurant bar. Restaurant bar, it was very basic, barely a restaurant, just done for specific, mainly non-site related purposes as a one-off favour when both national and local government were encouraging all temporary outdoor eating initiatives. It was inherently only temporary. It had no recognizable facilities, it was minimally equipped and was not there long enough to be of planning significance. You're also invited to find that the bar use associated with the restaurant use, taking place on the launch of the Sharks when the court order was served and people at the door asked if they could get a drink, was also so minimal as to be of no planning significance. Cinema. It is an agreed fact in the Statement of Common Ground, draft statement, supplied by the local planning authority that use of the premises as a cinema only occurred 6 times in August, September as part of the Potemkin Theatre Showcase fortnight of events. The films were shown silently over Bluetooth headsets. The showings were not commercial, they were only possible with funding from the Arts Council England. Sharks. You're invited to find that the installation of the 4 empty-headed sharks in the 6 days before the enforcement notice was served was so minimal as to be of no planning significance. You're further invited to conclude that the sharks, had it been installed as it was intended and as it appeared in the City Road Basin for 3 months, would also not have constituted a material change of use if it had remained in place for 3 months. Conclusions on Ground C. In Maine versus Secretary of State, it was held that the inspector was wrong if he was guilty of equating ancillary with an activity being carried out on a small scale. The meaning of ancillary encompasses activities that legitimately form part of the extant primary use. The appeal site's use as light industrial for production of art has a functional relationship with the artist's studios, being accompanied by the presence of a gallery, as the appeal site is an artistic hub. And again, I take you back to paragraph 60 of my learned friend's closing submissions, where he seems to concede the point. He says that Mr. O'Connor explained that the primary use as artist studios could have been left undisturbed by displays by artists not in residence, so long as they did not cross the threshold to primary use. This is exactly what they were telling Mr. Justice Murray. In Harrods and the Secretary of State is required reading. It is relied on in support of the appellant's case under ground C that the display of art is a type of use that is ordinarily incidental to the production at the appeal site. The appellant submits that you should first consider whether on its face the introduction of display of art would amount to making a material change of use to an existing use for production of art. A relevant factor is the reasonable expectation of neighbours and also what neighbours might expect to be going on the site involved in the production of art. Display of art has sufficient functional relationship with production of art. This was especially true whilst it was taking place internally when neighbours may have been oblivious. Things changed in 2020 with COVID-19 and sharks. Until then, use of the roof for art installations was apparently not the problem. Per se, it was alleged operational development without planning permission that was in use. Since 2004, Hackney have regarded the art installations at the appeal site, of which they've been well aware, as ancillary. 2016 was marked by installation of the flood house on the roof of the appeal site. It was there for all to see. There were no complaints or allegations about change of use about that. Murray J. did not understand what was said about ancillary use, and Hackney's submissions were to the effect, did not misunderstand what was said about ancillary use, and Hackney's submissions were to the effect that the art installations hitherto were merely ancillary. And I just pause there and ask you to recall the question you asked Mr. Connor, what caused the re-evaluation? And the basis of that question that you asked hit on exactly struck the right note, which was up until then, they had regarded it as ancillary. The ground C appeal and appeal A could only be relevant to displays of art, but Potemkin has gone and HVAC is partly dismantled. This ground has more application to appeal B. Events under ground C. The appellant's case is in the alternative in relation to events, see also ground A below. It's accepted that as stated in paragraph 7.7 of the revised guidance issued under section 182 of the Licensing Act 2003 that is referred to in the appeal statement of case, a temporary events notice does not relieve the premises user from any requirements under planning law for appropriate planning permission where it is required. And the guidance at paragraph 715 also bears out the evidence of Mr. Harley Gray concerning the number of tens which can be obtained 15 times a year, covering a maximum number of 21 days. Under ground C, it's submitted that the few events each year were and are ancillary. And you recall Caroline Rolfe, who was a witness of truth, saying it was a handful of events that she remembered during the period when she got there until 2013. Display of art installations, submissions under ground C, without prejudice to later submissions under ground D and ground A. On the 23rd of September 2019, Mr. O'Connor wrote, see page 43 in appendix 12, to the appellant's second statement of case, stating that the notice clearly sets out the breach of planning control. Given that we know now that Hackney regards, and more importantly then regarded, all along the Watchtower, Potemkin Theatre, Wickle House, HVAC to be art installations, it's clearly the case that their presence was not seen as sufficiently significant to be a primary use. This must be right, since no allegation of change of use was then made. In relation to section 1742C, the following further points are made. The inspector has indicated that it's all or nothing under ground C. A different situation applies to grounds A and D. In contrast, there's no Harry Potter type sorting hat for which allegations go under ground C. However, the sorting hat analogy could result in a disproportionate unfair result if a mixture of uses is alleged and only one of them is not a primary use but merely ancillary, whereas the others are distinctly different primary uses. It is submitted that ground C is wide enough to be read compatibly with European Convention on Human Rights to enable the 1742 statutory grounds to provide a sufficient remedy in such a situation and attached to just one of the material change of use components. Ground C is not confined to permitted development rights under the GTBO, but also means ancillary or ordinarily incidental, as the helicopter landing pad was not in the Harrods case. The ground C appeal can therefore be allowed if there's a sui generis use, B1C plus C3, plus an ancillary use. That was how the display of art was described by Hackney and adopted by Mr. Justice Murray. Mr. O'Connor now says display of art bore no functional relationship with the use of the appeal site, like goods brought into a farm shop from elsewhere for production of art. He is wrong. The two go together. They serve each other. The installations ultimately displayed were also worked on in the appeal site, e.g. the contributions to the Hackney Archive event, which by coincidence ultimately took place at Dalston instead. The question is whether use of the appeal site for display of art amounted to a material change of use. Hackney seems to have accepted that it did not until installation of sharks were afoot. Hackney was also wrong about that aspect of the case. In truth, the section 187B application was made in relation to anticipated change of use, but different considerations apply when assessing the accuracy of the enforcement notice and the basis to the ground C appeal. There was no change from production of art in artist studios plus C3 to B1C C3 plus use of the appeal site for events, for restaurant, for bar, for cinema, or for display of art installations as alleged by Hackney, because the extent of use of the appeal site for these other purposes never took place on sufficient occasion for such a mixed use to become a primary mixed use. You are invited to find that all the way along, the LPA regarding installations 1, 2, and 3 of the first enforcement notice plus airdraft and the 4 sharks as art installations. You're also invited to find that the injunction application represented the local planning authority's current thinking that full installation of the award-winning sharks tipped displaying art into a primary use. The 4 sharks had only been in the water 6 days by then. Whilst there, they were subject to an injunction pending a return hearing, which meant their position was precarious. Those 6 days may have been enough to support this 187B application that there was an anticipated change of use, but that short period was plainly not enough to amount to a material change of use of the appeal buildings, nor of the canal. The appellant submits that the planning authority's decision not to allege any material change of use when the 2019 notice was served, and 2, how Murray J. understood the council's case before him at the hearing on 28th August 2020, is consistent with the council's considered view held for about 16 years that display of art installations at the appeal site was ancillary to the production of art taking place there. The appellant's case is in the alternative. Sorry, wrong page. The relationship between the 2 notices and the fact that 2021 subsequently sweeps up the non-operational development that is subject to the 2019 one reflects Hackney's appraisal until the arrival of sharks, such installations were regarded as ancillary and not occasioning a change of use. The appellant argues that Hackney was right about this and the ground C appeal should be allowed on that basis because the introduction of the sharks was too short-lived as to tip matters over into a distinct primary use of the appeal site for display of art plus the other alleged mixed uses. Conclusions on the ground D appeal. Section 17B3, and I've set it out below in footnote 6, no enforcement action may be taken after the end of the period of 10 years beginning with the date of the breach, and 1913, for the purposes of this Act, any matter constituting a failure to comply with any conditional limitation subject to which planning permission has been granted is lawful, if at any time, if. And section 1742D, the initiation of the drawing room use was any matter for the purposes of section 1913 and was in breach of planning control. This is the case under ground D, and I submit that those provisions ought to be read together. Section 177 provides, on the determination of appeal under section 174, the Secretary of State may determine whether on the date on which the appeal site was made, any existing use of the land was lawful. Any operations which have been carried out in or over or under the land was lawful, or any matter constituting a failure to comply with any conditional limitation subject to which planning permission was granted was lawful, and if so, issue a certificate. And my submission is that no exceptional circumstances need apply before the power under section 1771C can be used. Reference is made to the Islington case. This case summarizes the law citing from the well-known cases of Thurrock and Swale. In the Islington case, see paragraph 57, the inspector applied the wrong burden of proof. Here, the burden is accepted and is amply discharged by cogent and unchallenged evidence. Moreover, see paragraph 14 Islington, the inspector was deemed to have misdirected himself by reliance on an intention to resume residential use and by application of incorrect presumption, see paragraph 42, when accepting that unauthorised residential use continued from October 2013 until February 2014. The case is distinguishable because in the Islington case, the premises were uninhabitable and a shell during renovation works and no one was there. Lang J summarised the law where he said the rationale of immunity is that throughout the relevant period of unlawful use, the planning authority, although having the opportunity to take enforcement action, had failed to take any action, and consequently it would be unfair or it could be regarded as unnecessary to permit enforcement. If at any time during the relevant period, the local planning authority would not have been able to take enforcement proceedings in respect to the breach, for example, because no breach was taking place, then any such period cannot count towards the rolling period of years which gives rise to the immunity. And it was for the landowner to show that at any time during the relevant period, enforcement action could have been taken. On this basis, it is accepted that not using the identified space for displaying art for any other purpose and the absence of intention of abandonment falls short of what is required because as identified in Swale, those matters are not the test. The appellant particularly refers you to paragraph 32 in which it was said, there was no presumption of continuance in respect of a change of use which had ceased to be an active use before any accrued planning right had arisen. Here, without relying on any presumption of dormant use, the appellant invites you to accept that the space for display of art installations at the appeal site, first where Mr. Armitage now is, and then on the ground floor after the school exhibition, never ceased to be an active use. On the contrary, had an enforcement officer arrived at the appeal site in the interval between exhibitions and found the 3 curators, or Miss Rolfe, in the adjacent office, busy trying to fill the exhibition space with various commissions in the making, and had they asked what's going on here then, the answer, revealing their activities, would have left the officer in no doubt that an enforcement notice, far from being a nonsense, would stop what was going on. In North Devon and First Secretary of State, it was held that there had been a continuous occupation of a holiday home for more than 10 years in breach of planning control, preventing occupation in the winter months, and the authority had failed to establish a new breach occurred every winter. The unlawful use became lawful once enforcement action could no longer be taken, which was 2013. The drawing room was exhibiting in May, June 2003. Just a comment on my learned friend's submissions, he refers to that date in 2003, but actually on the documents it was preceded by the Beachcombers, which was in 2003. It's referred into the Tannery Arts documents, it's referred in their annual report, and it took place in 2003. Alison Wilding's 10 years later Ron Eales, which remained on display until 2014. All the photographs of the drawing of the first floor photographs showing the steel column in the studio where Mr. Armitage now works at the appeal site. The true question is whether enforcement action against display of art was possible during the times when there were 3 curators and then Caroline Rolfe engaged in arranging commissions to exhibit there. Even when there was no public access, the site was in use for display of arts installations. You note the distinction between a display being on the walls before or following an exhibition. A transcript of the Ocado case was handed up, and I don't need to read that because my learned friend seemed to accept it in closing submissions. But the correct legal position is that a lawful planning right, which is accrued upon expiry of a time, is not lost merely because subsequently that right is not exercised for a period of time. I'm not going to read the whole quote because the principle seems to be in agreement. The main intervals relied upon by Hackney comes after the 10 years comprising the drawing exhibitions and the Art House Foundation's viewings arranged by Caroline Rolfe in the same gallery in 2012 and 2013. This means for the purposes of section 17B and ground D appeal, using the appeal site for display of art was already immune. The cross-examination challenging Mr. Gray on the period prior to Caroline Rolfe taking over came to naught. He explained the presence of the 3 curators working in the office and the continued presence of the gallery that is corroborated by the documents. Hackney focused just on public accessible events to argue that no enforcement action could be taken between shows. There is no dispute that large displays have continuously been on display since 2016. The appellant relies on the oral evidence, which establishes on a balance of probabilities that by May 2013, display of art installations have been taking place for more than 10 years. The oral evidence, in fact, it could be earlier than May if you count the beachcombers. The oral evidence in support of Ground D is comprehensive, honest, and cogent. Shiva Limited also rely on the corroborating documentary evidence to show that an enforcement notice could have been served despite the gaps. Hackney's case is at odds with practical planning that must look at the substance of what was happening, including between exhibitions, rather than merely the form it takes when the doors were open. You're invited to accept the chronology of activities and events as adduced on behalf of the appellant and find as a fact that once fully established in 2003, use of the appeal site for display of art never ceased to be an active use, and so that by 2013, that use became immune from enforcement and lawful. Any gaps thereafter ceased to be relevant. See the Ocado case referred to below. It could be referred to above. Display of art can take place without the public being admitted, but it's the moment that the doors open and the public have access until the moment a given exhibition closed that Hackney focuses on. But the enforcement notice does not say that. There is imprecision in the language of the enforcement notice. That lack of clarity touches on the Ground A appeal also. The appellant relies on the unchallenged chronology of drawing room exhibitions which took place at the appeal site. The appellant also relies on the sample of contemporaneous annual statements from Tannery Galleries and from Art House Foundation, corroborated by Ms. Rolfe, that describes the exhibitions put on at the appeal site. The appellant relies on the unchallenged evidence of Caroline Rolfe, the intervals relied on by the local planning authority in 2014 were not occasions when the identified space within the appeal site stopped being used for displays of art. There was no fraud involved in the application for charitable rate relief for use for displays of art. Ms. Rolfe was not obtaining a pecuniary advantage by deception. Ms. Rolfe was constantly busy with a number of concurrent subcommissions and funding applications. She was a witness of truth. Had an enforcement officer turned up between exhibitions, 1, then he or she would have found out what the Art House Foundation was set up to do. 2, he or she would have seen the dedicated area with the doors opening into the canal. 3, learnt of the history of the displays. 4, learnt of what was precisely happening in practice. And 5, having regard to the ongoing projects, even the unrealised ones at that point, then in all the circumstances, you are invited to conclude that Hackney still would have been able to enforce without having to wait until the next exhibition opened its doors. The appellant relies on the unequivocal evidence of Mr. Gray that he personally attended each opening events for the drawing room exhibitions. The appellant relies on the photographs of the artists sitting in the gallery in 2004. The appellant relies on the fact that Inspector Simpson stated that an exhibition centre had already been established. And I think you'll find that in Appendix 12 at, if I can just read that to you. This is a decision letter of Inspector Susan Simpson, and she is describing the appeal site and says that the appellant is the project's manager of Tannery Arts, which is said to be non-profit making operation. My understanding is that use of the appeal premises would represent an extension of the operations carried out in other parts of the building where artist studios and an exhibition centre have already been established.
Sorry, where do I find that document?
That's Appendix 12, page 86, and it's paragraph 16 on page 88, 2, 4, 6 lines down.
Appendix 12 of the statement of case?
That's right, yes. We rely on the fact that a site visit took place. But it's no surprise that she saw an exhibition centre there. It's exactly consistent with all the documents that you've seen.
Page 86, paragraph.
Page 88,
Page 88.
paragraph 16. About 5 lines down. And the site visit was on the 19th of January 2005.
Got it. Thank you.
Paragraph 141. The appellant relies on the fact that the council approved the premises that are eligible for mandatory charitable use business rate relief since 2000 on account of its use for studios and exhibition facilities for non-commercial fine artists. Ms. Rolfe was not challenged to the effect she was lying or wrong in saying for the period of 2013 until 2014 the premises were in use for display of art, which Mr. O'Connor maintains was always a primary use, but only an intermittent one. That viewpoint does not reflect the balance of evidence that you've now heard at inquiry. Even an empty gallery was an exciting thing to Miss Rolfe, whose unrealised projects come after the established use, which crystallised in 2013, had already accrued. Even an unrealised project did not mean the gallery space was not in use, and it could not have been enforced against. Applying the Cody case, any gaps since 2014 are irrelevant. There's no dispute that large displays have continuously been on the display since 2016. Floodhouse was in situ on the roof at the time of the borough's decision. The best contraindicator that Hackney can muster is that the 2016 enforcement notice appeal omits use for the display of art in the description of the appeal site, but that is not enough. The footnote, the beach house stands on the roof of the southwest building. On the first floor was the residential units, and beneath that on the ground floor were studios and an office, as they still are today, and as stated by whoever completed the application form at section 14. It does not displace the substance and reality of what was going on at the time. See also the reference in the borough's decision letter to the ongoing use of the premises for displays and exhibitions. Actions speak louder than words relied on by Hackney. The appellant relies on the oral evidence which established on the balance of probability that by the end of 2013, display of art installations have been taking place for more than 10 years. The oral evidence in support of Ground D is comprehensive, honest, and cogent. Shiva Limited also rely on the corroborating documentary evidence to show that an enforcement notice could be served despite the gaps. Hackney's case is at odds with the practical planning that must look at the substance of what was happening, including between exhibitions, rather than merely the form it takes. Sorry, I keep turning over the wrong page. Paragraph 145. Conclusions on the Ground A appeal. You are invited to allow the Ground A appeals for both appeals. In considering whether to grant historic. There is therefore no getting away from the need to identify the significance before being able to discuss what, if any, harm might be caused to it. There's no harmony or regular rhythm of buildings in the immediate vicinity of the conservation area. Here, that derives from their function and presence. Significance can be harmed or lost through the development within its setting, but the appeal site makes no contribution to the setting of the Hoxton Bridge. It is submitted that there is no harm, only enhancement. But even if there is a degree of harm which is denied, then it is modest. And the planning policy guidance says that which advises that degree of harm within less than substantial should be identified. Within each category of harm, which category applies, should be explicitly identified. The extent of any harm may vary. And the point here is that policy isn't such a blunt instrument as to say that the gradations of harm that are less than substantial, could be very much less than substantial, not such a blunt instrument to say that those gradations are legally irrelevant. If it's limited harm or modest harm, it's different to whether it's the top end of less than substantial. And the reason why it's not legally irrelevant is because public benefits and harm aren't hermetically sealed, they're relative to each other. And the weight of the countervailing factors relied on in support depend on the extent of harm that you identify. So my learned friend would have you conclude that it doesn't matter what it, as long as it's not negligible or de minimis, if it's something that's less than trivial, then you must give it the same amount of weight. I agree that considerable weight must be given, but it alters the amount of weight that has to be produced on the appellant side to outweigh that harm. It must have a factor. It's not legally irrelevant. And planning policy guidance advises that within each category, the extent of any harm may vary and should be clearly articulated. And what I say in paragraphs 149 is that this is because of the backdrop of the Bridge Academy that is such a dominant feature of the immediate surrounding area. Local experience also demonstrates it's unrealistic to expect the survival of any of the buildings comprising the appeal site in any other context than the present charitable enterprise, antepavilion or its like. In relation to the conservation area, the context includes that the appeal site buildings include the kind of historic ad hoc, shoddy, cheap and pragmatic alterations as per 2017 study. You are invited to find, in agreement with Mr. Froman, that the significance of the Hoxton Bridge is preserved by the presence of rooftop art installations at the appeal site because it is, as was demonstrated by HVAC, Potemkin and Floodhouse, possible to see and understand both things and to differentiate them and to understand the context. The barges moored on the north side of the canal more significantly distract from and obscure the bridge. The bridge physically imposes itself on the towpath user, whether pedestrian or cyclist, so that it's not possible to ignore it. Display of art installations at the appeal site do not detract from a towpath or canal user's ability to appreciate the significance of Hoxton Bridge derived from its form and detailing and its relationship with the water. That is so, whether looking at the bridge from the east or west, and nor with the Queensbridge Road Bridge when looking east. The display of art installations on the appeal site could not reasonably be said to affect the experience or significance of the Hoxton Baths. The display of art installation at the appeal site enhances the significance of the conservation area by adding a layer of interest and as an activity that resonates with, if not being a continuation of, the historic association of the conservation area with artistic industries that flourish in southern Hackney. Rather than being harmful, this is a material benefit that weighs strongly in favour of allowing the display of art installations at the appeal site. The effect of the appeal development on the character and appearance of the area, including the Regent's Canal Conservation Area, and the setting of neighbourhood listing buildings was carried out by the local planning authority without reference to what is next door. The Bridge Academy and Kent Wharves are not referred to by Mr. O'Connor, yet the effect of both are highly relevant features of the locality. The appraisal of the impact of the structures subject to the 2019 enforcement notice on the host building within the appeal site is a different exercise to assessing the effect on the locality of the conservation area. This has been addressed by Mr. Froman and his submissions above. The inspector's attention is invited to the relevant extracts from the appraisal, which is set out below. The language of conservation is not fixed with the need to harmonise, because new development in a conservation area does not have to be the same as what is around it in order to be acceptable. That is not the only way to fit in or be appropriate to conservation area. Art installations are different and don't need to relate simplistically to the buildings by mimicking its materials or forms. Then I was asked by my learned friend to set out more justification on the human rights aspect to this case, which I mentioned in opening. So if you'll bear with me, the next few paragraphs are digress in relation to the area of convention rights. You are a public authority and subject to the duty in section 6. So it is relevant if any part of your decision imposes a burden that is disproportionate to the legitimate aims, here, compliance with planning control. It would be disproportionate to dismiss an aspect of the appeal which would be acceptable if granted. Mr. O'Connor agreed that where dismissing the appeal would interfere with convention rights, and that would be a material consideration. It's for you to decide what weight to attach this interference. The interference is more severe if dismissing the appeal means the appellant is permanently prevented from using the appeal site for displays such as sharks. Paragraph 202 of the MPPF and the importance that must be attached to enhancing and conserving the country's heritage is subject to your duty under section 6 of the HRA not to act incompatibly with respect for rights that are engaged by the facts of this case. Where those rights are engaged, a more structured approach than is offered by paragraph 202 should be followed. The appellant does not say that the Human Rights Act instead of the National Planning Policy Framework, but submits that what is material under section 1772 of the Act includes both the MPPF and the consideration of the question that arise under the two convention rights that are relied on. Case law on Article 1 of the first protocol. The appellant refers to the Malster case, where paragraph 89, when Sullivan, as he then was, said the club is equally entitled to the enjoyment of its possessions. It should not be prevented from redeveloping the North Stand unless there are good reasons for refusing planning permission in the public interest. And just hold on to that for a moment and think about displaying art internally. If you're being asked to grant planning permission so that the appellant can use the premises for display of art, and you think that use of the rooftop is questionable and therefore you're going to limit it by condition, but you're happy with the internal display, then looking at this sentence here, the appellant should not be prevented from using the appeal site for display of art installations unless there are good reasons, and that means looking at it as conditioned for refusing planning permission in the public interest. And we say that if it's conditioned and it's static, and it's not using the pontoons like a ballet performance art to these pinch points that Mr. O'Connor was concerned about, it's not performing events, then it would be disproportionate to refuse permission at the appeal site. This was said in context of rights under the ECHR being a two-way street. So the fact the objectors were concerned about the overshadowing of a new football supporters stand at the Ipswich Town Football Club took the matter no further, as the club was also entitled to allow its rights to respect for its property. And that's to be able to develop as they would wish without good reason. The appellant's rights to develop the site are interfered with by a refusal of planning permission. Interference with the right has to be justified. This can be done when it's necessary. The notion of necessity implies that an interference corresponds to a pressing social need. And I apologise for putting the Sunday Times UK authority in your bundle. It's a very long one. And all that's relied on is that proposition that the notion of necessity corresponds to a pressing social need. Case law on Article 10. Freedom of expression includes ideas. Ideas include art. Here that means those responsible for the conceptualization and production of what would be displayed if the appeal is upheld. Their rights are being interfered with if the appeals are dismissed and there's no pressing social need to. especially because use of the roof can be conditioned. The appellant has a right to put on displays to showcase an Antipavilion award winner or runner-up, and such desire to display art installations is protected by Article 10. The question for you is whether use of the appeal site for display of art installations was a relevant expression that engages Article 10. It is submitted that dismissing the ground A appeal amounts to an interference with Article 10, as it would require removal of its existing displays and would mean that the requirement to cease using the land for display of art would also foreclose such future use. The question again is whether any such harm as you identify would be caused, none being admitted, to the conservation area or to public safety and amenity is so unacceptable that there is a pressing social need to prevent it. If so, dismissing the appeal may be said to strike a fair balance between harm to the conservation area and public safety amenity in the Article 10 rights. It's admitted that there is no pressing social need to prevent harm to the conservation area because there is no such harm, but even if there is, it is modest. Human rights as a material consideration are an essential ingredient of the balancing exercise and integral as matters of weight to be counted in their own right. This means you must decide how important they are and weigh them before embarking on the overall decision. They do not flow either way as an appendage, whichever way planning permission is decided. Paragraph 164, events, sharks, hatch and railings. Events were allowed before in 2005, that was by the Susan Simpson decision letter, and they can be allowed again in 2021. The ability to hold them is hugely important to the survival of the appeal site. Allegations of antisocial behaviour by those coming out of the appeal site, subject to the complaints that are listed in Appendix 2 to Harley-Gray's proof, does not mean that the behaviour is the measure for assessing the ground A appeal for events. That would be like assessing a traffic impact based on the likelihood of drivers speeding or based on the likelihood of drivers driving on the wrong side of the road or otherwise failing to abide by the highway code. There are other measures to deal with such criminality or transgression. The effect of the appeal development on the living conditions of neighbouring residents was discussed and properly dealt with in the 2005 decision letter. The current proposed conditions, or such further conditions as you deem fit, can meet the concern over the impact on neighbouring residents. There is no harm to the conservation area from properly regulated fundraising events that are controlled by conditions. You're invited to find as a fact that the ability to hold events to generate income for the primary use of the buildings, production, display of art, demonstrably merits attachment of significant public benefit, given the calibre of artists still presently working out of the appeal site, whose working environment is an asset to the community. Events that facilitate and subsidise that should be allowed. There should be little doubt about the fact that it would be disproportionate to refuse permission for conditioned events. Display of art installations. Sharks brought such happiness during the short time they were on the canal. People were in awe, especially children. The architectural heritage to which the conservation area is targeted is not harmed by the display of art installations. In reality, it is optimized, enhanced, and indeed preserved by it. Furthermore, use of internal areas for display of art installations, although enforced against in 2020, was not controversial, nor has it been, since Hackney were obviously well aware of it at the time of the CPO threat and at the time of Miss Simpson's decision letter. The effect on the vitality and viability of existing town centres. There's no evidence that allowing the Ground A appeal would detract from town centres. The provision of low-cost artist studios, a fundamental aspect of what Antipavilion does at the site, is obviously not an activity for high-rent town centres. Properly conditioned use of the appeal site for display of art installation enhances the character and appearance of the area, including the Regent's Canal Conservation Area. The Secretary of State is invited to agree that the appeal site integrates its settings with innovative and creative contextual architectural responses as it has done for the last 2 decades. The overwhelming number of support letters received in relation to the appeals, and I reject my learned friend's attempt to demote the weight that you attach. I think it's the 293 letters, because some of them, and I would submit a small proportion of them, adopt a form of wording that was suggested, please write in to the planning inspector. I submit that there are obviously many letters that weren't prompted, that were the substantial amount of them were written in and volunteered as an instantaneous prompt reaction of their own. Paragraph 172, alternatively, even if you adopt Mr. Dyer's opinion, case law explains that while such harm to the significance of a heritage asset is a consideration to which the decision maker must give considerable importance and weight, that importance and weight can be outweighed where the public benefits are sufficiently strong, as they are here. You are invited to accept the evidence from Mr. Harper, from Mr. Butcher, regarding the wider benefits to the public that result from the presence of art installations at the appeal site. Mr. Froman organised his own research and formed his own conclusions. Mr. Beglin attempted in cross-examination to show that Mr. Froman's integrity and objectivity was compromised. The attack failed and should be flatly rejected. Focus on Mr. Froman's selection as a member of a jury was a bad point. Augmenting the jury with a planning barrister and a heritage planning consultant was obviously a prudent move. And I'm not sure he said he did vote for Thames Gritty. I thought he voted for the actual winner. The attack failed and should be flatly rejected. Mr. Dyer's CV does not include evidence of attending training for experts in giving evidence. The evidence adduced on behalf of the appellant establishes that the presence of the art in the canal has sufficient public benefit to provide the clear and convincing justification that case law requires. Such displays of art have a proper role on the Regent's Canal because they bring people into the conservation area, make it more vibrant and encourage engagement with the arts. The importance of the response to the sharks and the message, "London, we love you," is not to be lightly dismissed. The impact on the 4-kilometre long conservation area as a whole is negligible or modest, and the appellant contends, in any case, clearly positive. The public benefits are formidable. Once installed, like Ron's eels, Hackney may want them to stay, in harmony with public opinion, in which case the condition limiting external installations to 15 months to display could be reviewed in the light of all circumstances. You are invited to accept that conservation allows for change and even demands it, and that new uses for old buildings is an essential key to preservation. You are invited to agree with Mr. Froman's opinion that the art installations add considerable interest and vitality to this part of the canal, as well as the broader local context, including the conservation area. This applies both individually to each new art installation and cumulative. Harm is denied because displaying art in the canal and on the roof of the appeal site enhances the character and appearance of the area, including the canal conservation area. Mr. Dyer did not oppose planning permission for internal exhibitions and displays. Here is a list of material considerations which you are invited to find each attract significant weight in favour of allowing the Ground A appeal. First is that it would further Hackney's policy objectives, which include encouraging arts and culture. In a plan-led system, compliance with one of the most important policies relevant to the appeal must weigh substantially in favour of allowing the appeal. Second, fostering young artists and craftsmen has been recognised as a public good since antiquity, stroke Elizabethan times. You are invited to accept as a fact that allowing Ground A appeal in Appeal B furthers that policy objective, and this is a material consideration that must weigh significantly in favour of allowing the appeal. There is unchallenged evidence that the anti-pavilion competition, like Art House Foundation before it, has provided, and if allowed to do so, will continue to provide, a test bed for realisation of experimental art and architecture without the complex politics and economics associated with traditional commissions. You're invited to conclude this showcasing opportunity is rare and is of a significant public benefit. Display of art and artistic activity resonates with, if not being a continuation of the historic association of the conservation area with artistic activity, which is documented in the conservation area appraisal. The appeal site is easily accessible with sustainable transport modes, which means it's in a sustainable location. Dismissing the appeal will interfere with the Article 1 First Protocol property rights of the appellant, which is a matter that attracts substantial weight and should be integrated into the planning balance because interference with ECH rights is a material consideration. Dismissing the appeal will interfere with the Article 10 rights of those seeking an opportunity to showcase their work at the appeal site. The interest generated by the external display of art installations at the appeal site has increased the footfall in the canal conservation area, which broadens the appeal of the area in a good way. Allowing display of art installations externally contributes to placemaking in a way that is consistent with artistic activity in the area the conservation area appraisal identifies. There is no loss of employment floor space. The ideas and innovation of the future are bred by fostering a fertile artistic environment where there is an opportunity for emerging practitioners to display experimental works, and it carries a public benefit for future generations. There is a public interest in fostering curiosity and engagement with the built environment. There is a public benefit in more people being able to see inside and experience the industrial legacy of the ground floor spaces of the appeal site when accessing the roof or attending art exhibitions or events. To the extent that the buildings reveal their industrial past, which is said by the council to be the reason for their designation, the visitor gains a far more vivid experience of them by going inside and giving people a sense of the buildings and their activities, materials stacked outside. Giving them access for events and display of art gives them a different experience of what the conservation area is said to be about. There is no legislative requirement that conservation areas must be protected from any development that does not positively preserve, but it so happens that what is before you facilitates retention of the existing buildings, which would preserve the appeal site. Preservation of the fabric of the existing buildings would be a bonus to which significant weight should be attached. Refusing permission incentivizes the inevitable redevelopment of the buildings nearest the bridge. The public love the sharks. The fondness for what has happened at the appeal site is matched by the absence of public complaint about what is displayed, distinguished from complaints about disturbance arising from events or performances which can be met by conditions as they have in the past. See the 2005 decision letter. The support from those using the canal is not to be relegated as unimportant, and Mr. O'Connor agreed that the considerable level of public support is a material consideration weighing in favour of allowing the appeals. The appeal site has previously displayed art, bronze eels and shellfish, and the council thought that they should be retained. Allowing the appeal permits an evolution of engagement with the canal by the buildings on the appeal site. If allowing the appeals fosters the appeal site's engagement with the canal, then that is a material consideration in favour of the appeal, because such connection is an important historical function worth preserving in this way. The fact that buildings can cope with the sliding doors facilitates engagement with the canal. One further material consideration is that any harm could be ameliorated by conditions that you embark on an overall balancing exercise in using the lesser extent of harm as conditioned, e.g. on the basis that there will be a nighttime curfew, control of external lighting on use of external areas when assessing impact on residential amenity. A temporary permission causes less harm than permanent permission, but you are entitled to grant a permanent permission. To the extent any harm is identified, allowing the appeals under Ground A is nevertheless justified. This is because the public benefits, when aggregated with the combined weight of the 15 different material considerations, or it should be 16, different material considerations listed above, make use of the land for display of art installations and associated fundraising events an acceptable use of the appeal site. It is entirely consistent with the applicable statutory and policy framework to allow the Ground A appeals for what is at the heart of this case. Moreover, it would be disproportionate to refuse permission for conditioned events. It would also be disproportionate to eliminate display of art installations, including the sharks externally. It would be disproportionate to refuse permission for hatch and railings since they were previously allowed. The green wall, once established, makes a positive contribution and does not harm the Haggerston Baths. Conclusions on the Ground F appeals. You referred to paragraph 23 in Ahmed, where the Court of Appeal, paragraph 23 in Ahmed, where the Court of Appeal referred to your wide powers. The inspector has wide powers to decide whether there is any solution short of a complete remedy of the breach, which is acceptable in planning terms and amenity terms. If there is, he should be prepared to modify the requirements of the notice and grant permission subject to conditions. With the extent of this jurisdiction in mind, you are invited to find that the steps required by the notice to be taken or the activities required by the notice to cease in relation to the railings, the roof hatch and the platform clearly exceed what is required to remedy any breach of planning control which may be constituted by those matters, or as the case may be, to remedy any injury to amenity which has been caused by any such breach. You also referred to paragraph 25 in the Ahmed case, on which the appellant relies for the explanation given by Lord Justice Richards of the relationship between grounds and F. The Secretary of State's argument set out under paragraph 19.4 in Ahmed that section 177 is not wide enough to empower a grant of planning permission for a previously authorised scheme, which had lapsed in the Ahmed case, was rejected. See paragraph 27. If the previously authorised scheme could be regarded as including what had been built differently and was the subject of enforcement. This is true in relation to the railings and to the staircase hatch on the appeal site. See inquiry document 7 that included approval for access to rooftop level and railings. The essential point that the appellant makes, see paragraph 29 in Ahmed, underground F, is that all that was needed to make the requirements 4 and 7 of the 2019 notice and the relevant parts of requirement 7 and the 2020 notice acceptable in planning terms was for the railings and hatch to be modified. You are invited, if necessary, to make a consequential variation of the steps required under Ground F as contemplated by Lord Justice Richards in the last sentence of paragraph 29 in Ahmed.
Can I pause you there? The point about the hatch and the earlier planning permission, document 7, I don't recall. Did that permission include an access hatch? Is that the point?
Yes, that's what I understood.
I know it included railings. I don't recall it including an access hatch to the roof.
We've got the document, got document 7. My understanding from document 7 was that it was more than the railings. I'm corrected by my client that it didn't envisage the hatch.
Right, that's what I thought.
But it did include the access to the roof. That's right. It did include the access to the roof, sir.
It relates to the stairwell. It doesn't relate to whatever structure it is, structure 4.
That's right.
Right, okay, understood.
But this is, just pausing here, what Lord Justice Richard talked about was wide powers. What Lord Calm which was subject of a previous permission. And in relation to the hatch, we invite you under 177 to allow the Ground A appeal on condition that it's modified as suggested in Mr. Gray's evidence, so that it's brought back from the west elevation to allow the railings to continue all the way down, because at the moment the hatch stops the railings coming all the way down. Do you remember? The railings stop at the hatch, whereas if the hatch was just and it's a modification to allow the railings to continue down the side of the building.
No, I don't. Okay, can you continue? I'll need to think about that one. I don't want to hear any more about it.
I submit that you can allow the 177A appeal on condition that the hatch is modified according to a scheme to be agreed with the planning authority. I'll continue. Ground G. It's submitted that carrying out dismantling of structures simultaneously is not feasible. Supervision is also required. A timeline of 6 months that permits consecutive operations to be carried out is sought. That period is required in relation to the roof hatch. A design that allows the roof hatch to fold down flat would need to be discussed with the planning authority. If the hatch is approved, then a reasonable time to remove other items would be 3 months. So it's just a question of matters taking place simultaneously, sir, as opposed to consecutively. And again, this is consistent with what was said in the January 2020 grounds of appeal in support of Ground G. I'm not differing from what was said there.
Okay.
I don't know if you need me to go through the authorities, but I think there's nothing controversial in the authorities. The Malster case is the first one. I've given you the quotation. The Sunday Times is the second one. The Buxton case on reversibility, I've given you the quote for. The North Devon case was the winter closed season. The Dill case you're familiar with. Quick save on de minimis, where the cars were just there for less than a month. And the Ahmed case we've gone through. Birdle I just put in there because it was decided in 1972. It's engraved on everybody's heart. Everybody knows exactly what's said. But it was decided 25 years after the introduction of town and country planning. Now, what is another 40 years, 50 years nearly since then. And what we do know about dwellings and separate functional planning units, it's a lot clearer now in my submission that where you've got dwellings and they are in the way that they are in this building, in separate functional buildings, that they are clearly a distinct planning unit. And that's how convention would approach it. Just looking at the photograph of the building, it's obvious that they're separate. So in my submission, they are a separate planning unit. And then the Harrods case, you've got that, which is about, incidentally, Harrods was about rooftop. And nobody blinked when talking about the rooftop being available for uses incidental to the shop itself. Just they drew a line at a helicopter port. So we would invite you to allow the appeals on the basis that art does actually bring something to this location.
I've understood that. Okay. It's 9 minutes past 2. It's definitely time for some lunch. I propose that we break now until 3 o'clock to come back and then hear the costs applications. You're nodding, Mr. Beglin. Yeah, okay. Right, I'll adjourn now until 3 p.m.
Wonderful.
Right, welcome back, everybody. It's 3 o'clock. We're moving on now to costs applications. Mr. Beglin, your file has got an updated costs application. I've not read this. Does it vary in any material way from the previous version that was sent a couple of days ago?
Not in any substantial way. There are a couple of typographical changes, and I think there's one additional sub-point, but that's really it.
Can you help me with what the changes are? Because I have digested the previous iteration, but not this one in the time available today.
Yes.
So what's the sub-point?
So the sub-point is new 14F, which is just the reference to the Lady Heart of Chiltern case. As you recall, Mr. Froman referred to, and I referred to in closing. No, F should read the absence of any articulated, clear and convincing justification. We're all working for Mr. Cottle, if you have the copy that was provided this morning, that indicates the change. Previous F has become G and F is new.
So is that the only thing that my attention needs to be drawn to in terms of what's changed, apart from typographical errors, which I'll probably figure out for myself?
Yeah, so the rest, and sorry, I haven't got the comparison version, the rest is absolutely trivial in terms of changes. The only point that I wanted to draw your attention to in terms of the referencing is in paragraph 4, because that's referencing, you may recall earlier on in the inquiry, I was struggling slightly because I had an electronic combined version of the appellant's appendices. And so that's where the references for 661 and 666 come from. So if I tell you where they can be found.
Yes, I was going to say, I don't know what 661 and 666 are.
No, and that's where my fault. I was using my numbering at the time. But within the appendices to the statement of case, there is a big appendix which contains the materials in the High Court Judicial Review. And that has pagination within it on the top right. And I've asked my learned friend, because he's got some technological support over there that always seems to be able to find these appendices fairly quickly. But it's in that appendix, and the equivalent page numbers are 390.
So 661 is 390?
661 is 390, correct. And then following on from that, because it's the same appendix, 666 is 395. And 390 is an email from Mr. Gray to Councillor Nicholson, which contains the quote that I've referred to, fear of embarrassment. And then 395 is a letter from Shiva dated the 7th September 2020.
So, sorry, which appendix are these from?
So that's the actual number of the appendix I'm still struggling with, but it's the very large appendix 10. Thank you. They're in the same appendix. So if you look at appendix 10, 390 will be an email and 395 will be a letter. If we're in the right appendix, which is the High Court JR bundle. Indeed.
Okay, right, I think I've understood that.
Thank
Anything
you.
else in terms of referencing that's
So
going to help me?
there isn't anything else in terms of referencing. I take it from what you said that you're therefore content, as it were, for my application just to have been read by you and then to hear
Yes, I
Mr.
don't
Cottle's
want it
response.
read out.
No, grateful.
I don't think that's necessary. But then it brings me on to the question of the appellant's response to the council's application. Is there a response in writing, or am I to hear it orally? Yeah, okay. Do you have the copy of the written response? Thank you. Is the second page meant to be completely blank? It is, okay. I haven't seen this, so I was going to suggest that you read it out. Yeah, because I haven't seen it, and I don't want to adjourn again. So if you read it out, then perhaps we can come on to the additional point.
There's a difference between the parties they're also mistaken in saying I think Chancellor's might be said to have left. Not despite it taking place. Yet now that they are in the middle Barry was notably required, especially in the veracity of direct access means that the press and the council meeting. Taking the common ground and simply the council.
Sorry, Mr. Cottle. You may have guessed why I'm intervening.
Thank you. Do you want me to start again?
No, unless somebody has particularly said no. Okay.
Paragraph 6. There was silence. It took nearly a month for the council to respond. That was irresponsible conduct. The council unreasonably delayed and effectively thwarted production of the statement of common ground by not responding until the 11th hour. They even refused to sign the one that we have their deletions. The time taken in cross-examination by the local planning authority far exceeded the 30 minutes it predicted. The documents comprised two full ring binders. No additional cost resulted from additional documents because the ones you were referred to mattered. What made things much more difficult was the terrible acoustics, which made things so very difficult and slow during the first 4 days of the inquiry. The site was given over to an augmented reality theatre set development in September. The council left the matter of a site inspection until very shortly before the inquiry, giving very little choice over when they were available, which did not match the appellant's available dates. They again left it far too late. Inspection should have been sought before each of the enforcement notices was served. The council was invited to visit at times that were workable for the appellant and its theatre company. You were invited to dismiss the council application for costs and grant the well-founded one made by the appellant. The oral point is that the accusation that we were writing to the council saying, why aren't you responding to us? And not getting the engagement, and my client becoming frustrated with the local planning authority because they weren't willing to meet him to discuss matters. And planning authority rely on the language, a pejorative language that was used in those emails. And my submission is that that language hasn't added to the costs of this inquiry. What matters is the things relied on by the appellant in their cost application, which is that events could have been met by condition and could have been taken out of the equation had a sensible discussion about conditions been pursued.
On that point, I don't understand the condition point because there was no planning application for the council to condition.
When I was cross-examining Mr. O'Connor, I put it to him that conditions could meet their concern over events. And the point is that when there's a ground A appeal ongoing, the time taken at the inquiry could still have been reduced and narrowed, and the proofs need not have gone into it in so much detail. If, for example, as we found out at the 11th hour before the inquiry began, the council accepted that there were only 6 cinema showings connected to Potemkin. And we could have found this out and we could have had a discussion and that would have narrowed the issues before the proofs had been exchanged.
How do those two things relate? How do those
Well,
relate? Potemkin and conditions.
First of all, what is in issue are cost incurring steps as a result of unreasonable behaviour. You, sir, are looking at the enforcement notice. I'm looking at the period after the enforcement notice. I'm looking at the time when we're getting down to preparation of proofs. I'm looking at the time taken at the inquiry. And what is being said, and we'll get to it in the appellant's application for costs, is that there was a failure to discuss and engage over matters that would have helped you, sir, because the issues would then have been narrower and reduced. And so my learned friend relies on my client's frustration, the pejorative language that he's said to have used. I'm saying that didn't cause any further costs. What caused the costs is their failure to discuss things that really mattered to how long the inquiry took. We'll refer to it. So that's the only further points that I wish to add, sir.
So the engagement point about not being willing to meet, is that post-service of the notice, post-issue of the notice?
Well, there are 2 stages, but in relation to the language that's being relied on by the planning authority, what I'm pointing out is that post-service of the enforcement notice, there was that failure to engage. But you're right, we do rely on the fact that had they, after, I think it was March, April, when the anti-pavilion award was announced that the sharks were going into the canal. And what Mr. O'Connor said was that due to the IT failure, the authority weren't able to act on that information. And my point is that the IT failure didn't prevent somebody coming round and saying, look, we are concerned about this, and establishing the facts to their satisfaction. So it's both, sir, before and after. The point that I said was really, if first of all, you've got to establish something unreasonable. If they say that my client was unreasonable and the language he used in the email to Guy Nicholson doesn't establish a causation of additional cost incurring steps.
I understand the point. Yeah. Mr. Beglin, do you have anything further you want to say in relation to the council's application?
Just briefly, by way of reply, firstly, paragraph 1 of the response mischaracterises the approach that the council has taken to ground D. So, as you know, we rely on the case of Beach and the idea that what is necessary, straightforward application of guidance in that case, is for the ground D appeal to succeed, to demonstrate that a mixed use has been going on for the requisite period. So that's our case. And we say, for the reasons that I've already rehearsed, that the ground D appeal is hopeless for a number of reasons all already set out in closing. So that's the first point. The second point relates to paragraph 5, and our position is, and so you'll have your own view about this, but the reason an inquiry was necessary in this case was because ground D was being pursued, and therefore there was a need for the evidence to be heard under oath. And a good amount of evidence was given in the attempt to make the ground D appeal good. So that's why we were here through the inquiry process. If that had not been raised as an important ground of challenge, then we would probably not have been doing this via an inquiry, and I probably would not have been here, and probably nor would Mr. Coffin. In relation to paragraph 5, to try and now say that an inquiry was inevitably required, especially when the veracity of the council tax relief application is not in doubt, I mean, that just logically doesn't carry one anywhere, because no one has established through this inquiry that council tax relief is granted on the same basis as we are interested in, whether or not there's a continuous and uninterrupted planning use. And that simply hasn't been explored through the evidence. Paragraph 6, Mr. Gray is choosing to instruct Mr. Coffin by direct access. That's a matter of preference for him. As matters have shown, so even to you, Mr. Gray is well capable of handling matters within a forensic inquiry process. And so on that basis, I think you have seen, or it has been sent to you anyway, Mr. Gray's draft statement of common ground, together with comments that the authority made in relation to that. So I think Pins was copied into that correspondence. And I would simply ask you to review the draft of the statement of common ground that he sent in, because it was by no reasonable assessment an attempt to agree parts of the case that might be subject to agreement. It was 90% pure advocacy. And so it was obvious that we would not be signing up to that statement of common ground. And that's why we sent Mr. Gray the guidance in relation to statements of common ground and invited him to review the statement of common ground. And things essentially ran into the sand in relation to the statement of common ground. So that's the point in relation to that. It seems a harsh criticism of the authority in paragraph 7 to blame us for trying to make available facilities that we thought would accommodate what we had, what inferentially we were to expect, which was a large number of members of the public coming along to support Mr. Gray's case. Of course, as we now know, that simply didn't materialise, but it seems a harsh criticism in those circumstances of the local authority. Paragraph 8, in relation to inspection, again, if this is the response that comes from the appellate, then it deliberately misunderstands the point. The application that we made was for me and the team, as council instructed, to go and view the property. So it's not something that sensibly I would have done before the issue of the enforcement notices. And that was the request that Mr. Gray sought to put all kinds of qualifications and limitations on. And that's why I wasn't able to inspect the site, sir, before I arrived with you. So, sir, none of the response here really serves to indicate either that there are other good reasons why we needed to be here for an inquiry, or to provide a defence other than the defence that is already provided by Mr. Coffin in his substantive submission to the cost application. So our cost application, I suggest, will largely stand or fall on your assessment of the merits about the grounds of appeal. But I do, in addition to that, still maintain the point about the overall conduct of the appeal by the appellant, and I've referred to various elements of that. But the overarching approach is one of disproportionality and unreasonableness. But for this response to say it was okay to have 2,079 pages because they were all useful to you, well, so large chunks of that information you specifically said was not relevant to the inquiry because it was related to, for example, the injunction or the stop notice or other extraneous matters. There ought to have been a far more considered sieving exercise of that material.
On the disproportionality point, am I helped with that by any particular paragraph in the MPPG?
So no, the MPPG guidance doesn't purport to be exhaustive in relation. It gives examples of what can constitute unreasonable behaviour. But it comes back to a point, I suppose, Mr. Collins would argue the other side of the coin. He says in certain respects we haven't engaged and so on. It all comes back to this point about unreasonable conduct. If someone behaves in a way that is not reasonable because they produce a plainly excessive amount of documentation, and that documentation needs to be read, as it was by me and doubtless other members of the team, that takes time, it takes expense, and it tends to prolong inquiry proceedings. And so to the extent that that material was unnecessary, extraneous, or really of peripheral worth, bearing in mind how much of it there was, then I say that that is an example of unreasonable behaviour. But I accept it doesn't fall directly within the examples that are provided within it.
Okay, thank you.
Over 10 years. Over 10 years. What Beach doesn't do. They were saying we were required to show that the restaurant requires it doesn't touch on it. But the high court proceedings have identified.
I had to be gifted with immediate and precise recall with everything I've done over the last few months.
Sorry, explain to me again your point on the Beach case.
In Beach, it was a situation of A plus B and an argument that they've been an immune use because it's been going on for so long. During the period that it's been long came new use D. That changed the nature of uses going on and the introduction of the new mixed use to punctuate previous period and reset the clock. so that it became A plus B plus C. But it all comes back to looking at the statutory provisions, and 177, as I've explained in the closing submissions, is absolutely plain, and it's really going back to Mansi as well. If there's an established use, an Ocado, if there's an established use that's become immune, then the grantee appeal should be upheld. And in this case, the C3 use, and whether or not that's a separate planning unit, is critical to your application of the beach case. Because my learned friend relies on the...
In this beach analogy, what is the D? Is this the bar,
C3.
restaurant, and C3?
Well, my learned friend gave you a whole list of everything that had happened, including the restaurant, the bar, the cinema, but he stretched back to C3 as well. Physically a separate planning unit, even a separate planning unit at the time of Miss Simpson's visit to the inspection, to site inspection.
So I'm not going to engage in ping pong, but I will simply observe, leave you to read the beach case and see what you think the statute means in light of that, and whether or not my learned friend's construction of the statute can possibly survive the beach case and its decision. But what I will say, and I'll be corrected if I'm wrong, is it was in my learned friend's closing submissions that for the first time we heard the suggestion of 4 planning units. Now, I don't recall that having been mentioned before, but as I said, we're now in cost submissions and it's not the right time to reopen these matters.
Okay. So then we come to the appellant's cost application. This is the version that was emailed yesterday.
A, B, A, B.
I don't know where you're reading from, sorry.
Paragraph. Page 3.
Sorry, paragraph 8, A,
B,
B.
and then on page 5.
Are they, so they are new, are they? So if I compare that to the version that I've read, the rest is intact, unaltered, and I only need to read those paragraphs.
I believe that new paragraph as it's in the document.
So disregard what I've seen before. It just means that I haven't read this, so I need to get to grips with it. I need to understand it, and I don't need to read it if I've read a version of it before, and I'm just looking at the new bits. So do I need to read the whole document, or can you tell me which are the new bits? I'm trying to avoid an adjournment. I'm trying to play spot the difference with what I've read, with what I've just been given, and I am stuck. And so unless I leave the room and go and read it, I'm not going to be able to do that unless someone can take me through it. Looks like page 1 is pretty much the same. So paragraph 8A, that's a new paragraph, is it? And paragraph 8B?
That's new. And then old 8B is new 8C.
Right, okay, so I've read that. The new,
Old 8C
yep,
is new 8D.
yep.
Old 8E is new. Missed one D to leave. So basically, it's just one letter, one number up. G in the old one is H in the new one. H and I is a correct.
Yep.
Old J is gone. Old K is gone. Old L is gone.
So L and M are new. Right, okay, that makes sense. Give me a moment, I'm just going to read these paragraphs. On paragraph 8A, the local planning authorities should not have opposed the ground day appeal in respect of internal art installations and simply sought conditions. I don't understand how those conditions should have been sought. Help me with that, because there was no planning application. Am I not understanding the point?
After the ground area being as you're approaching the question I got from Mr. O'Connor, to whether Hoxton arts policy submissions finding that there'd been no appraisal by Mr. Moment's reflection would realise that it was in familiar with the policies. By process of elimination. Moment, of course, would have woken that actually there is something here that I have no opposition. No opposition. You yourself said any installation or use of its operation development require a fresh planning application. There was a discussion that ought to have been carried out by a local planning authority properly conducting itself, like of its own policy that promotes culture. Looking at the application of the facts of the case to this.
I think what I'm struggling with on this point is that it's not as though the council has refused a planning application where those reasons for refusal all relate to matters which could be conditioned. So when you say sought conditions, I don't see what the mechanism would be for doing that on all of the reasons for issuing the notice.
Sometimes there is no evidence offered in opposition to a ground, or it's said that the local authorities are agreeing that conditions would have no objection in principle. It's one thing for them to have, we'd say, fairly quickly issued questions, but it's another thing and to lengthen the proceeding. And it's taken an inquiry. My response to you, sir, is that there was that obligation of them once in receipt of the grant. When we just developed together grounds C, D, J, and H, so a lack of inquiry. C, D.
C, D, J, and H.
Yes, I would put those down as
Do you mean lack of investigation?
failing to make inquiries, failing to properly investigate, failing to have regard. I think those all comes as a free.
Sorry, we've jumped about. So which paragraphs? Just remind me. Yep, yep.
F, A, failing to make inquiries. All about failing to make inquiries.
Failing to investigate. Yeah.
And if I could come to paragraph E. Again, like my learned friend said, in respect to the account, a lot depends on your findings on the merits of the case. If you find something to go on the other side of the scale in terms of we submit to the planning authority in the knowledge of all the lessons before, even after exchange of proofs when they saw Mr. Harper was saying, failed to really assist the inquiry by embarking on the required balancing exercise. And my submission is just to simply put their head in the sand, that there are no public benefits. Not reasonable. They needed to assist the inquiry by carrying out the required balancing exercises. Yeah, required. Had they done so, then they might have acknowledged the existence of it. Then we wouldn't have had to need all the evidence about the existence of the public benefits. They could have said, well, we accept all of that. If so, so what? Because it's still not heavy enough, substantial enough to outweigh the harm. But they didn't. They said no public benefits, and so we have to need evidence. And you said, I think, something about this is not perhaps not a normal case, because we started hearing evidence about art and the benefits of art. And we wouldn't have had to have that whole tranche of evidence if they'd accepted in a more balanced view. Well, notwithstanding the fact that you rely on public benefits, which we acknowledge, we still say they don't add up to enough, and then we wouldn't have to need evidence to prove it.
So the point is, it's the use of the word no. Okay.
So even if they disagree, the classic mistake of planning authorities is cautiously. From a point of view, without asking themselves whether the Secretary of State may disagree with them. The Secretary, what could be wrong about that? Shouldn't they have gone on to consider the Secretary is against this one? Does consider buildings, so the buildings being preserved. Go on to consider what are the benefits. Take a substantial amount of evidence. Should we just take it away? Next point that I wanted to direct your attention to is the statement of common ground. I do realise deleted those parts which the authority weren't prepared to accept. Left in those parts which they were prepared to accept. And my submission is that this process should have begun less than 48 hours before the inquiry, as my client wrote with a statement of common ground. And this response from Mr. O'Connor came back at the 11th hour. Now, my learned friend may complain that the appellant had drafted an unrecognisable statement of common ground, but it began with site. It had planning history. And there were other things like the surface area of the ground floor, dates of the dates that the structures were taken down, which perhaps which is a process, a timetable set by pins expected to have been carried out to assist the inspector. These things should have been sorted out so that an agreed version of what Mr. O'Connor hadn't deleted, without the deletions, would have been signed by both parties and would have been before you, and we wouldn't have had to have the amount of evidence that we require. That's what statements of common the Labour government of Mr. Brown and the Conservatives, Mr. Cameron in 2010. Conservatives said, well, this is what you've got that we will do, we agree. And Labour would say, well, no, not having any of that. And one says yes, and they go into coalition, one says no, they don't. The thing here is that when Mr. Gray submits a statement of common ground, it was possible for Mr. O'Connor to have taken the bits that he didn't strike out and say, well, these are the bits that we agree. But Mr. Gray could have signed that, and you could have a statement of common ground that would cut down the issues. Did it far too late, sir? And so our complaint is that the timetable set by pins for statement of common ground is there for a purpose, it wasn't. I think that they didn't recognise our statement. Things in there that should have been, that should have been before. In fact, Mr. O'Connor could have signed the one. We will not clear it over and rest it. The next point that I wanted to address you on conditions apply. And this again is like Mary Friend said, it probably depends on the merits of the case. It rather flows with how you decide the case. Mrs. Simpson, Inspector Simpson, Miss Simpson, decided that events were possible. There was a curfew of hours on the roof, and there was a curfew of nighttime hours. Licensing history by the local planning authority, recently, as I was told, it wasn't beyond capability, even if it didn't lead to a successful for the planning authority to embark on that point. And you've asked me, well, why should they have done that before? The parcels after you receive the grant. Planning permission is being sought. Previously allowed, subject to condition. What's your problem with that happening again?
Are you saying that the 2020 enforcement notice could have been avoided by conditions?
We say that the 2020 enforcement notice, by talking to us and engaging with us for investigation, once it had been served, once the grounds of appeal had been lodged, once they knew that Section 177 allows you to grant planning permission for parts of it. 177, we went through part of these. I think there's a different paragraph response to your letter, which is the scope of the grounds of appeal. That's sorting out. So it didn't apply to ground C. We did accept that we could mix of uses. You do have the power under Section 177 grant planning permission any of the part of the matter. And this is the width of your power, sir, which is to grant what is acceptable in the public interest. Planning control. So coming back to the point here, on conditions, if events were granted last time in 2000, what's the likelihood of this inspector looking at events and seeing they were controlled last time? Surely similar controls this time will be sufficient. You know, I think time could be saved in my perspective. Now, I'd like to invite your attention to paragraph K.
So if Mr. Coppell's going to continue, sorry, I thought he might have finished, but if you could his microphone.
Sorry, subparagraph K. And I have to say that when I looked at employment floor space, I'd seen it was referred to in Inspector's Borough's decision, but there it was in the proof of Mr. O'Connor. And so I went back to the evidential base. There's a 2016 Hackney study of floor space. And I was trying to analyze, for the purposes of presentation of my client's case, which zone we were in and what the statistical basis post-COVID and the change that work patterns that's made to the 2016 evidential base. And I embarked on an entire process of preparation in relation to an item that wasn't put in their statement of case. It was introduced in his proof.
It wasn't in the statement of case.
It wasn't in the planning authority's statement of case. As it was in Mr. Connor's proof. And I thought he'd thrown it in because he'd seen it be mentioned beforehand and he didn't want to not say it. but it wasn't a well thought out part of his evidence. And it betrays an error in failing to specify what the alleged change of use is said to be from. Because if you think that production of art has been going on at the appeal site since the end of the last century, and you accept that production of art is carrying on in 2021, what is the loss? So as soon as the local planning authority accepted production of art as an existing use, the loss of employment floor space fell away. But they should have accepted the production of art as an existing use, as they're fully aware of it from the High Court proceedings, if not from the early decision of Mr. Burrows and Miss Simpson, and the compulsory purchase attempt, where it's accepted in the press, where the chief executive, Mr. Ray, was talking about the production of art and how they liked it. So it was unreasonable of Mr. O'Connor, who, with respect to Mr. O'Connor, did rely on a number of theoretical possibilities rather than practically what I call practical planning, which is based on the facts. And that leads me to the last point, which is intensification. And my learned friend repeated the mistake with respect to him in his closing submissions on intensification, because if that was their case, doesn't that presuppose the prior existence of something that's been intensified? Which comes back to this ground C point, which is it's a big storm in a teacup if in fact the local planning authority accepted that display of art installations had been ancillary all the way along. And it was that they were saying was intensified into the change of use. And that is consistent with our understanding of their case in the High Court and how we understood they regarded us, which is the ground C appeal, that the display of art was ancillary. And if they have got a case on intensification, it was introduced in a haphazard and late way, came about in Mr. Connor's oral evidence, wasn't in the proofs at all. No more. So we say that there is a respectable basis for awarding partial award of costs, and it would be full if you felt that the events and the conditions could have satisfied the planning authority, but partial award of costs, certainly in respect of the matters that I've submitted to you.
Mr. Beglin, in terms of the council's response.
Thank you, sir. First of all, at a high level, if it takes in the order of half an hour to explain to you why the local authority has been unreasonable, there probably aren't clear and compelling high-level points relating to unreasonable behaviour. There certainly aren't in this case. Mr. Cottle again refers to his construction of section 177, but of course we're inviting you to take a different construction of that provision based on the Beach case, and I will not rehearse the closing submissions again, but you know our point is that where that section uses the word use, what it means is the use that you're concerned with, and the use that we're concerned with here is the mixed use allegations in the enforcement notice. And beyond that, I'll just invite you to go back to deal with Beach. In relation to the paragraphs of my learned friend's submissions, first of all, in relation to paragraph 6, what has happened is Mr. Gray or Mr. Hoxton now, instructed by Mr. Gray, has gone back to the idea that the council is misbehaving, a hostile and unreasonable approach. In relation to paragraph 6, I can simply say this. 2 High Court judges didn't agree. In relation to the grant of an interim injunction, without going into the detail of that process, so you will know that it's something that High Court judges think very carefully about before they make that kind of relief. They do it as a matter of their discretion. If there was any hint that either of those judges thought we were behaving unreasonably in our approach, then they would not have made the orders that they made. So that, at a high level, I would invite you, is sufficient to conclude that there is no unreasonable conduct demonstrated by the authority. In fact, insofar as one distills anything from the judgment of Mr. Justice Murray that I don't want to spend too much time on, because we say it doesn't deal with the issues before you. But what it discloses is an approach by a local planning authority that is absolutely sound and that the judge effectively endorsed by his interim order. Now, turning to the statement of common ground, and so just so that you've got the chronology correct, in case you haven't got the emails that we suspect were ultimately forwarded to PINS, but and I don't think you've been given the chronology by my learned friend, but the start of the chronology is this. On the 5th of August, Mr. Gray sent his email to us containing what I will describe as an argumentative and tendentious statement of common ground, which bore no resemblance to what the guidance required. It's up to Mr. Gray, if he chose to take advice from Mr. Cottle or someone else, about how a statement of common ground ought to be sent it to us. But be that as it may, we sent an email back the very next day, the 6th of August, at 1:34 in the afternoon, supplying the guidance to Mr. Gray and inviting him to produce a statement of common ground that complied with the guidance so that we could consider it and then make modifications to it. Mr. Gray did not take us up on that invitation. Instead, 2 weeks later, on the 20th of August, he wrote back saying, well, if you don't agree with my statement of common ground, please can you make some alterations to it? So we had taken a position where we said that we really don't think what you're doing complies with national guidance. We sent him the guidance. He didn't respond to say, yes, it does comply with the national guidance. He responded 2 weeks later to say, well, extract the bits that you think ought to be extracted. So that was how the statement of common ground position developed. But at all events, so that in terms of what expense that might have saved on either party's side, that is probably a minor point. The reason I rely on the statement of common ground in my cost submission is because it's part, I say, of a pattern of behaviour where you can see that Mr. Gray is taking a tactical approach to litigation. Turning to paragraph 8 and the sub-paragraphs of the submission there. So again, at a high level, what I say about that is that these are in reality all complaints that relate to the substantive matters that you're being asked to decide. So it will be up to you to consider whether or not, if you find against the authority on any of those issues, whether there has been unreasonable conduct. I submit to you at a high level that plainly the authority's approach has been reasonable. We have provided professional evidence dealing with all of the points that we've sought to maintain through the inquiry process. And in relation to the idea that we hadn't carried out sufficient investigation, so you have the officer reports. You can look at those for yourself and decide whether or not this authority had sufficient material in front of it to issue enforcement proceedings at the time that it did. And you can do so, you'll form your own view, but you'll do that in the knowledge that at just about the same point in time, a High Court judge thought that we had sufficient grounds to go for relief in at least one of those matters, and recognised that Mr. Gray was, as matters then stood before that judge, and committing a criminal offence because there were existing enforcement proceedings with which he had not complied. Might tell someone something about the duty to investigate in those kinds of circumstances. Going on to my learned friend's point about material change of use, again, sir, I've dealt with that in my closing submissions. It's being mischaracterised now for purposes costs. What we say about the uses over time is that, first of all, there may well have been periods of de minimis use property. Secondly, there will have been times where the level of use was ancillary or incidental. And then thirdly, there will have been occasions, and they were much more pronounced in the recent history, where it's clear that the display of art installations was a primary use of the site. And so that is the context in which the word intensification arises. It's signifying that difference, a difference in intensity of operation between that which planning simply doesn't regard as being relevant because it's de minimis, that which planning regards as potentially being relevant, but which is ancillary or incidental to an existing lawful use, and then that which takes on a form where it's a primary use in its own right. And there shouldn't be any confusion about that. It's been clearly spelled out in our case in closing submissions. In relation to public benefits, the point that's taken here is simply a matter of disagreement between the local authority and the appellant, and upon which you will reach your own view. But the authority has considered the material that's been supplied to it and has articulated why, in this location and in these circumstances, it does not consider that there is a public benefit from what has been happening on this occasion. So for my learned friend to say that, well, we should have been driven to another conclusion is an attack on the merits, and that's something that you will decide. But there's no doubt that this material was taken into account and considered. In relation to the employment point, Mr. O'Connor dealt with that fairly in his evidence and didn't seek to pursue the point, and I haven't sought to pursue the point through closing submissions. So on the contrary, that is a good example of a local authority recognising where it was appropriate not to place continued reliance on it and not seeking to do so. In those circumstances, so I say that there is nothing in the application that's been made to you that begins to demonstrate unreasonable behaviour by the local authority. References to what may have been going on in different domains, such as licensing, the prospect of conditions if a planning application had been made, really can't assist you in deciding whether or not this authority behaved reasonably.
Just to invite my own friend to accept that on the response came from as if there was a 2-week gap.
If anyone wants to read that email, or if the inspector wants all of the chronology in relation to the statement of common ground, we're quite happy to
What was
provide.
the 6th of August response? That might be helpful, yeah.
Setting was, I'd said my district statement of common ground. Stevenson for the council. Badly dropped some. Statement of common ground. First class. Statement of common ground drafted with appropriate considerations. Clarify safely as far as it accepts. What they do say by confidence. Basically, if you draft, right, further alternative available. Council refuses to cooperate, as it always has before the courts. Approach to this enforcement act being capable of consistency.
The point is, you've asked them to strike out what they don't agree.
I've given eventually they did after a month.
Right, I've understood the point. Okay.
One reference. Very Bermondsey rather than
Sorry, you've lost me. The Beachcombe
There's
case.
a reference in my written submission 2003,
Mm-hmm.
and I prefaced that orally by actually Beachcombe's report, because I'm not referencing that submission.
Is this in your closings?
It's not. I only had it.
The importance of the point, sir, is that said to have been exhibited in 2000 or 2000.
You're going to have to help me out. My brain is fried. I don't understand the point.
The inception of drawing rooms is documented at the appeal premises absolutely clearly, but everybody's working. May, June 2000.
Mm-hmm.
I added orally this morning a reference to which I'm not sure that was.
Okay. Sorry, Beachcombe is not a case, it was an exhibition. Do you have anything else to say in response to the council's response to your cost claim? I'm not inviting you to say anything else, it's just whether you have any further points.
The important point really firstly, for my learned friends, was ancillary.
Does anyone have the attendance sheets for today? Could I have those, please? Thank you. Right, thank you all for your contributions. The inquiry is now closed.
Thank you, sir.